Okay, we're going to call a meeting to order, and it's the meeting of April the 10th at a little bit after 1 p.m. And the first thing we're going to do is have the Pledge of Allegiance. And George, you want to lead us in the Pledge of Allegiance, please?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, George. Okay, Mr. Garber, do you have any reports to report out that were taken in closed session?
Yes, sir. The board took action to amend an indemnity agreement dated December 6, 2005 with First American Title Insurance with regard to coverage for a title policy to be issued to LS Power or an affiliated agency, or entity, I'm sorry.
Thank you. Now we need the approval of the order and the agenda items.
Mr. President, I'd like to, on item number 11, discussion on proposed economic development rate wheeling on page 102. It's under action. I'd like to move that to information.
Okay, anything else? Okay, is there a motion for that?
Move to approve.
Is there a second? Second. Please vote. Thank you. Okay, public comments. Anybody with public comments, please step to the podium and state your name for the record. You have 5 minutes. Okay, Mr. Morgan will be up then.
I'm happy today. I don't have any comment. I'm usually mad at any comment.
Mike Morgan, Brawley, California. One of the questions I'd ask, probably you need to clean it up in your closed session minutes or something. It appears that the board had made an election to dismiss Judge Candy, the Superior Court judge that basically ruled in your favor on the Salton Sea up in Sacramento. I never saw it reported out of your closed session or agendized, but I question, what he faced at the trial was 3 weeks of your lawyers telling him that the state had no commitment to the Salton Sea. None. Zero. And that's what got him so concerned about Imperial Valley's future and its air quality, because he saw no one was going to be able to take care of the Salton Sea. 2 weeks ago or so, when you had Mr. Dumars here, he showed you a number that I think comes out of your own documents, that there's a $1.3 billion liability at the sea that Judge Roby at the appeals court said you can't collect from the state. So before you go along dismissing judges quickly, I think it's important to get insight into the amount of knowledge he had about what we're facing at the Salton Sea, because that's why he found the QSA deal unconstitutional. That leads me to the second point. I keep hearing from Stella, and I hear from Anthony and Jean-Pierre, a deal is a deal. One thing this board has to be aware of is within 2 years of your deal, the San Diego threatened to take you to arbitration to change the local entity. That was the money they agreed to put up in the negotiation to take care of the third-party impacts of the fallowing. That part was a cornerstone of your deal, because John Carter felt it was worth $120 to $150 million. They threatened to sue you. You changed the deal. You took $50 million. Then the deal, they threatened to sue you or take you to arbitration over the rate that they had in the contract for the water. Dr. Brady went and took care of that, maybe to the cost of the IID of $1 to $2 billion. So I got to figure out which portion of this deal that you want to stick to. I made a comment a couple weeks ago that the state, after this board voted on it, got veto power of the Joint Powers Authority. And I believe Stella said they don't have that. Again, ask your lawyers. They have veto power over the Joint Powers Authority. Those are three major deals that they've changed. And they had to do that to get it through the courts, whether it was good for you or your ratepayers or not. So I think it's important to do that. Now, if I understand recently, the same guy that does the television here is running Stella's and John Pierre's campaign. If that's true, I think the board should look at that. Because as you know, you paid him over the next bid. And someone would have to ask, was that a form of mordida? Is that a form of cronyism to a guy that's giving you advice on your campaign?
They call that grab.
Graft. I thought it was mordida.
Mr.
Anyway.
Morgan, I do not have a contract with Spectrum Advertising for my campaign. My campaign manager is me. My campaign fundraising person is me. I run my campaign. I make my decisions.
I didn't say you had a contract. I understand you're
And
getting.
as far as calling it
you're
a deal,
getting advice.
the reason regarding the QSA, it's a signed, valid contract. I don't want the IID to be the agency that blows it up, because the consequences are going to cost us millions of dollars, and we're going to lose our water. Basically, that's what I'm stating. Now, you like to kind of take the facts and kind of squish them and move them around to suit your needs. And you stand there and you, as far as I'm concerned, you're not telling the truth. And I know that during public session, we're here to hear what you have to say. We shouldn't respond. But when you attack me personally, I have to speak for myself.
Stella, the facts are the QSA deal has been changed 3 times under threat of arbitration. If you don't realize that, it's time for a change.
That's the Pearl Valley First motto, time for a change.
Yeah.
Next, go ahead, Mr. Kuhn. You're up, Bruce.
And a pleasant good afternoon to all. Bruce Kuhn, Drew Road. First things first, I get perhaps a little corporate memory, and I will just inject it for what it's worth. Since I was the swing vote, since the QSA was approved on a 3-2 vote, and I'm glad to see you're supporting it, Stella. So. Different. Anyway, it is a deal. The IID was contractually obligated. But as I've said up here before, we're contractually obligated as long as all the other contractual obligations are met by those who were contractually obligated. And when this was put together, it was put together under a lot of duress and stress and a lot of pressure and a lot of threats from the federal government and the state government. And one of the things, and I've said this before and I'll say it again, one of the things that Don Cox was really worried about was that Salton Sea, and he didn't want us to be responsible for it. And when we were in Sacramento negotiating this thing, we told them that we would not take responsibility for the Salton Sea. And we didn't care who did it or how they did it or who they wanted to put together. They could form a JPA, whatever. Or Met could take it or San Diego could take it. And none of them would. And Richard Katz, who was a senior advisor to Gray Davis, said, well, then the state will take it. And we said, fine. Now we have something to negotiate for. So the state took the position that they were going to take care of the Salton Sea, and they contractually obligated themselves through negotiations up there to take care of the Salton Sea. Now, all these contracts, all 35, 37 of them, are interlocked. And one of the most important things to Don and myself and Lloyd Allen and Rudy was that if this thing did break, if it didn't happen, if it imploded, it was of the utmost importance that it not be the IID. Well, people, I stand here today to tell you, it isn't us. It's the state of California. If they cannot be held for constitutional reasons to be contractually obligated to the contract to which they negotiated, you have a breach. And all the other contracts are hooked together. So if you break the chain, you have a breach. Not on our part. So Stella, it isn't on our part. So if we stop the water, then let them negotiate, someone, whoever, but not us, the responsibility for the Salton Sea. And then that $1 billion that's been bandied around because the lack of finances from the state goes away. If they don't find someone to take care of the sea, then the deal implodes, but not because of us. So you stop the water. So either way you look at it, this is not our fault. We didn't break it. And the QSA of today is not the QSA that I signed. This thing's been changed. And God, when I agree with Mike, I get nervous. But it's been changed quite a bit. And if you're worried about the state not coming up with their $1 billion or whatever, and we've negotiated almost 1.2 or 1.5 billion away after I'm off the board, you got hit twice. The state's not living up to its obligation, and somehow, some way, this thing got changed to forgive almost 1.2 billion in water revenue. I don't understand it. It is what it is, but it shouldn't be. And if people didn't like the QSA when it was brought here, they sure aren't going to like it now because it has changed. But you don't have to follow the contract if the other people are not following theirs. If they've broke it, they broke it. Let it go. And it's not our fault. Couldn't be better.
Thank you, Mr. Kuhn. Anybody else have any public comments? Mr. Oscar, you got to go to the podium.
I would like Mr. Hanks to clarify this thing for me. Mr. Hanks.
Introduce yourself, Oscar.
Oh, my name's Oscar Gonzalez, Mexican hillbilly from Calexico. Mr. Hanks, I've heard a lot of money. I wish I could keep $1 million of that in my pocket. I've heard that IID has caused, during the tenure of the QSA or whenever the water was sold, that over $2.2 billion has cost the IID. I hear a figure, 300 million plus 156, and then something that adds up to 2.1 or over $1 billion. Can you clarify that for me, Mr. Hanks? I don't understand that.
Well, I don't know where you're getting the numbers from, but our last report from Mr. DeMars showed that the business case had $1 billion from the state budget into the business plan that's no longer there, so you can figure right from the start it's $1 billion short.
Because consumers, and down in my reservation, they're just concerned about water rates not going up and jobs, that's all. They don't understand the intricacies and the complexities of the QSA, the Dead Sea, who's going to pay for it, and no, we're not going to pay for it. People in Calexico, they're just concerned about two variables, rates going up or going down, and jobs. And I'm not so sure that any of you on the board has done anything about that. Thank you.
Thank you, Mr. Gonzalez. Anybody else from the public want to speak? Okay, thank you. I'll bring it back to the board level. We'll start with Director Hanks.
Yeah, just to follow up on your comments, Mr. Gonzalez, I think the rates and jobs and these issues are a concern everywhere, all over the Imperial Valley. But in my district, Division 3, the Salton Sea sets up there. And the people are very concerned about the health hazards. And the way we're going, it looks like we're letting the state off the hook. So who's going to pay for it? That's the issue. And so it boils down, and I heard it. I heard some people at the podium talking about, well, whether we're blowing it up or we're not, and so forth. Well, my question is, what QSA are we validating? Are we validating the pre-amendment QSA, or are we validating the post-amendment QSA? Since he filed for validation, this thing keeps morphidating on us. We've also have decisions that are being made, the removal of a judge, that didn't come before this board for a discussion or a vote. You know, that's the duty of elected officials. Everybody out in that community has a right to know what position a board member takes on an issue. I'm going to, at this next board meeting, I'm going to ask for an agenda item be placed on that we notify the appropriate federal officials, state officials, that we want them to come here in 90 days and give us a presentation on their official action that they are taking, that they have committed to on the Salton Sea. There was legislation passed at the federal level years ago. We all know what's in the QSA, what the state promised. And the language that was put into the QSA said a failure to appropriate funds is not a defense. That was put in there. That wasn't put in for us. That was put in to notify the state. If it wasn't for them stepping in, there would have been no agreement. And with the term in there, failure to appropriate funds is not a defense, and now we have our own lawyers standing before an appeal court and saying just the opposite. My question is then, and I'm going to address this to Mr. Garber, if the state fails to appropriate, is it not the position then, a legal position that we can stop the flow of water?
The state is obligated to pay mitigation expenses in excess of that which the parties are obligated to pay. Those expenses don't all come due at one time. They would come due gradually over time. The budget is prepared on an annual basis. The state and the agencies all participate in various budgeting and other technical committees. If the state were not going to pay, if it were going to adopt a budget and not pay, that's one scenario. If it wasn't going to pay whatever share was in the budget, or if it were going to be refused to adopt the budget. If a situation came up in which mitigation required under the QSA was not moving forward, then the parties would, IID and other parties would be in violation of the State Water Board order and environmental permits, and the transfer would stop. And there are provisions, at least in the environmental cost sharing agreement, that require the transfer to stop. IID would not continue to transfer water if it couldn't provide the necessary mitigation. That's the way I think it would happen if that were the situation.
Yeah. When we're talking about excess dollars, if you live in the vicinity of the Salton Sea, and how many mile radius, I couldn't say. I know when the wind blew this last time, I'm still suffering from it. But you know, if you're waiting until the 133 million is spent, or waiting until we spend our nominal 133 million, which is probably up there about 385 million or more, then you have a health hazard on your hands. And I don't think we have the luxury of waiting till the state decides, well, maybe they will, maybe they won't, or the federal government. And I'm going to be requesting that this board put it on the agenda and that we discuss it and see what is the appropriate plan moving forward.
Sure. The QSA requires the parties to mitigate the impact of the transfer. The QSA does not require the parties to restore the sea. If the transfer stops, arguably the impact stop, and any other problems that you have are not related to the QSA, but they're restoration issues. If the state does not participate and is in breach of contract, I think the transfer would stop.
Well, I think the top priority is the health issues up there.
Yes, thank you. I have two comments today. First, for Mr. Kelly, during your opportunity to comment, I was going to give you a heads up if you could give us an update as to where the IID is at and the deadlines and the dates that you had set in your 6-point action plan. I'm not looking for a response right now. I'll just give you some time to summarize that. And a second comment today is also this concern about removing Judge Candy. I've checked my notes from meetings, and I don't see where it was discussed, and I don't remember it being discussed or getting that information that we were going to move in this direction. Now, with that being said, it quite well would have probably would have gone down with the complexities and the divisions amongst the board, that they would have gone along with this direction to remove Judge Candy. But as an elected IID director and a member of the community, a lifelong member of the community, I resent not having the availability and the opportunity to perform my elected duties and participate and make those decisions and let the public know what those decisions are and put out into the community. Be them successful decisions with where the direction goes in the way I want it to go, or if it goes against me. And I just ask that the council please have an open ear to these comments and don't take us in this direction again. We already have enough division in this community, enough division between the IID and the county, enough division amongst the IID and the farmers, enough division amongst the IID and the ratepayers, and plenty of division amongst the IID board. So we really do need to work together to get some kind of consensus, and the general counsel works for the entire board. There are no super board members. Last Tuesday, this information came out in an email to me. Last Tuesday, at around 6 o'clock, I received this email. Well, last Tuesday, we had a 7-hour IID closed board meeting and open board meeting. 7 hours we were here together. And in closed session, we never heard about this direction that the IID was going to go into, about having Judge Candy removed. We never had the opportunity to vote on it and put it out there. Yet I get emailed about 6 o'clock in the evening after that 7-hour session. I made some phone contacts to some of the other agencies involved, specifically Imperial County, where I used to be employed. And I come to find out that they knew. The Board of Supervisors all knew. Everyone else knew. Received this same email that I did from a private source off the streets. Knew before the IID Board of Directors knew. And that's just plain wrong. And like I say, I resent it. Looking forward to future discussion on it. I believe next board meeting we'll have an interesting closed session. It's my understanding that the IID attorneys will be here. The QSA attorneys will be here. I don't know if there'll be an open, but that's where we'll take up this discussion for the part 2. Thank you.
Director Mendoza.
Oh, what the hell. I'll go ahead and speak my mind. After listening to Mike Morgan speak under public comments, it's very interesting to me as a board member of this board to think that some of the comments made by this board, some members of the board, we might as well have Mike Morgan sit on this board because it's a reflection of what he says when he comes up under public comment. And folks, this is the bottom line. The bottom line is that I feel that water, and state law says, federal law says, water is a public resource. We have certain people in this community with Mike Morgan and the Imperial Group that want to take control of that water. Very simple, that's what it is. That's the bottom line. And I commend this board for going forward in protecting the water rights, which are held in trust for the beneficiaries. And that to me means public resource. And we're going to have people come up to the mic with Mike Morgan's and the other ones, his clones, and talk about all these other issues. But remember, the bottom line, they want to control the water. That's the bottom line. Okay, that's all I have to say.
Thank you, Dr. Sanchez.
Jeff and Kevin, the comments about Director Hanks on having a workshop or a 90-day so we can continue to further. I think he brings a very good idea as far as timelines, as far as what happens when who doesn't pay for what, when, and have those benchmarks laid out the next 30, 40 years. I think we could take advantage of that time and plan that out. I'm under the assumption that the court planning to plan, so to speak, in the future, especially during that time of the workshop, is, from what I understand, is the appeals court decided that because we're not asking for state funds right now, that the state really hasn't breached the contract because we haven't. So to say that they are in the failure to pay is an assumption that hasn't come to pass. It may come to pass in 5 years, 20 years, 40 years, if that money is needed. And I need to know that information as we go through this workshop in 90 days or wherever, how much time that is needed to prepare it, to be able to, provide a good timeline for the district. Do you have, what's the assumption on?
The issue before Judge Handy and the state court was not whether the state breached or the state could pay or the state couldn't pay. The issue was whether the language in the contract that memorialized the state's promise was constitutional. Okay? The state has not breached. The state has not been required to pay funds for mitigation until the funds put up by the parties is exhausted. Judge Candy ruled that the language was not constitutional. The appellate court ruled that this language is constitutional. In other words, the state is contractually bound to pay. It's also bound to indemnify, which was never criticized by Judge Candy and never brought up. So there's two different ways in which the state is required to protect the parties. Neither of the courts are talking about whether there is a breach, whether the state can pay, or whether the state can't pay. They're talking about the constitutionality of the language in the agreement in which the state agrees it will pay under certain circumstances.
Thank you.
Okay, thank you. I just have one comment. No, the only comment I have is I run my own campaigns. I've always run my own campaigns. I put my own signs up, and I think most people know that. Nobody runs my campaigns for me. And I'm very good friends of Rob Zimmer because I worked for his father, Bill Zimmer, when I worked for Visco Flying Company back in the early 70s, and I knew Rob when he was a little boy. So I have a friendship with him. But I have never written a check to him yet. But before the campaign's over with, I might write him a check. Depends on how things go, because I think it's going to get hot and heavy. And I enjoy hot and heavy campaigns. So we'll see how it shakes out. The other thing I want to say about all this water issue is my father, who died in 2007 at the age of 99 and a half years old, came to this valley in 1907 when he was 6 weeks old. And he told me that when he was a kid, they fought about the water. And when he was alive, they fought about the water. And he told me when he was going to be dead, they were going to still be fighting about the water. He died in 2007, and we're still sitting here arguing about the water. So it's all very interesting. So anyway, that's my comments. Mr. Keller, do you have any comments?
If I might, I'd like to come back to the board with a status report on the 6 points. And on the other issue about the disqualification of the judge, while I think that probably was a natural litigation strategy of IID, this question was posed to me at a meeting of the Farm Bureau yesterday, and my response was that it should have been put squarely in front of the board and wasn't, and I regret that, and I've conveyed that to Mr. Garber. So I think at a minimum in the future, the board ought to be able to have first shot at that and not hear about it elsewhere.
Mr. Kelly, for the record, did you hear anything from me prior to this board meeting or before Mr. Morgan in an email concerned about the judge's decision and whether the board it off the streets or anything?
No, I did not. I was contacted by another board member Tuesday night after the meeting, and I was unaware of it myself.
I'm quite capable of speaking for myself.
Okay, Mr. Garber.
Apparently, I'm the only person who understands that what goes on in closed session stays in closed session. I can't say anything to these issues.
Okay, thank you. We'll move on to, let's see.
Wait a minute. Are you saying it was discussed?
I'm not saying anything because I'm not going to talk about what happens in closed session. I'm not saying anything.
You're not saying no about it. Are you?
I'm not.
Are
I
you
can't
saying,
talk about what happened in closed session.
Well, I'm saying it wasn't discussed.
Okay,
and if
I
you're
know you
saying
are.
it, I'm saying you're a liar.
Okay, I didn't.
No, that didn't come out closed session.
Okay,
I'm also saying you're a liar. Received an email from you saying that where this happens and goes down, and we don't have reporting at a closed session. I don't know whose choice that was. I'm new on the ID board, but if this is going to be a consistent problem, then we need to make some changes for transparency purposes and correct them, so we don't find ourselves in this situation.
okay, we're going to move on to information.
Mr. President, I object to the language being used to our staff. It's unacceptable,
Bill, I
unprofessional.
object to a lot of your language, too.
Well,
Okay.
but not in open session.
No, I'm running the meeting, I'm sorry. We're moving on to the information, and we have nothing here on a consent, so we're going to move right into information. First thing is review and comparison of procedure policies number 3101 and 3103. Mr. Taylor.
Good afternoon, President Membo, members of the board. My name is Vance Taylor, Assistant Counsel. A few board meetings ago, the board had requested a comparison of the new draft IID policies 3101 and 3130 against the provisions of the Public Contracts Code. Just as a point of clarification, as a preliminary matter, I'd like to point out that the Public Contracts Code is actually a fairly complex and convoluted document, and there really isn't any one code that applies to all different types of public agencies. If you look in your agenda packet at page 2, 3, and 4, I just took the liberty of putting the index in for part of the Public Contracts Code so that the board could see the manner in which it's broken up, the level of complexity. I probably should point out that irrigation districts are handled under Article 35. Cities are handled under Article 4. So what we decided to do and what we thought would be most beneficial, rather than just, trying to compare what we've got in our own policy against, different aspects of the Public Contract Code, we tried to pick an agency that we're most similar to. As a municipal utility, we're probably most similar to a city form of government, so that's the type of public agency that we decided upon for purposes of this comparison. And staff believes that the comparison will demonstrate the overall reasonableness of the IID draft procurement policy as compared with the statutory analog for cities. So I will start with Policy 3101, and that is generally applicable to the procurement of goods and services here at the district. And comment 1, we've kind of already addressed that. Just as a matter of clarification, there isn't a singular state public contracts code that applies uniformly to all types of government entities in California. Rather, the code is broken down into separate and discrete divisions, parts, articles, chapters, sections, and they all apply to different types of public agencies. Cities addressed under Division 2, Part 3, Article 4. IID is addressed under Division 2, Part 3, Article 35. So I just wanted to point that out for clarification's sake. Comment 2, the purpose of comment 2 is just to indicate the authority pursuant to which IID has developed its policies and procedures relating to the procurement of goods and services. IID and cities are both required to adopt such policies and procedures pursuant to Government Code Section 54202. Comment 3 addresses the circumstances under which a public project must be awarded to the lowest responsible bidder and what that term means. Cities are required to award to the lowest responsible bidder on any contract in excess of $5,000 that meets the statutory definition of a public project. What is a public project? That is actually defined in the statutes. For cities, a public project is the erection, improvement, painting, or repair of public buildings and works. It is work in or about streams, bays, waterfronts, embankments, or other work for the protection against overflow. It's street and sewer work, and it's the supplying of materials and supplies and materials in connection with those type of public projects. So already you can see that it's even, with regard to cities, it's a fairly limited circumstance when they're actually required to award a contract to the lowest responsible bidder. And that sort of begs another question. What does lowest responsible bidder mean? That means in order to award to any particular vendor, that vendor would have to be the lowest monetary bidder. That bidder, or the bid itself, would have to conform to all the material terms and the requirements set out in the bid package. And third, the bidder has to be determined to be a responsible bidder. In other words, there has to be an appearance that this particular vendor has the experience and the trustworthiness to carry out the contract and to perform the job. So all three of those elements have to be satisfied before you can award to a particular contractor under the lowest responsible bidder methodology. If all three of those components are satisfied, then an award can be made. Although IAD is not legally required to award to the lowest responsible bidder except when public works are paid for with bonds or by limited assessment, in connection with the work that we've done on the policies recently, IID has opted to award to the lowest responsible bidder on all sealed bids. Typically, sealed bids would be used for the acquisition of materials, supplies, equipment, and on construction projects that that have a defined scope, specifications, and a defined schedule. The next comment is comment 4, and the purpose of comment 4 is to explain why employment of attorneys and legal professionals is exempt from the competitive solicitation requirements of the purchasing policy. There's nothing unusual about an exemption from the competitive procurement requirement where the retention of professional services is involved. In fact, Government Code Section 53060, applicable to both cities and IID, provides that special services such as professional legal services are generally exempt from the competitive procurement requirements. In fact, IID could have even painted with a broader brush and exempted all professionals, but we chose not to do that. Comment 5, this highlights the rule set forth in the Public Contracts Code that prevents cities from splitting up projects to avoid the competitive procurement rules. As an example, a city government might try to split a $6,000 public construction contract across 2 solicitations in order to avoid the requirement that all contracts for public construction in excess of $5,000 be awarded to the lowest responsible bidder. In this instance, IID has adopted a similar rule because we have different rules for instance, small dollar purchases in excess of $50,000 require a little bit different treatment. As with cities, staff would be prohibited from splitting up projects in order to sort of game the rules. The next comment is comment 6, and it is intended to highlight the fact that cities under the California Public Contracts Code are required to competitively solicit on all public projects in excess of $5,000. There is no similar competitive solicitation requirement for cities with respect to contracts for goods and services that are not related to a public project. IAD's policy, in contrast, provides that all non-exempt purchases in excess of $5,000 will be subject to some form of competition. So I think we've gone above and beyond as far as that goes. Comment 7 outlines the manner in which IAD will handle the procurement of materials, supplies, equipment, and public construction projects with a defined scope, specification, and timeline that are over $50,000 in value. Those items will be handled by sealed bid, and award will be made to the lowest responsible bidder unless the written justification is placed in the file which notes the reason that the lowest responsible bidder was not chosen. Comment 8. This comment addresses the manner in which IAD will handle the procurement of services and construction projects that did not have a defined scope, specifications, and/or timeline. These types of procurements are generally going to be handled by RFP, RFQ, or QR, and the best value methodology will still be used on those types of solicitation. This methodology is largely consistent with what cities do because cities generally need not award service contracts to the lowest responsible bidder. Additionally, cities are allowed to award large-scale design, build, construction projects in excess of $1 million based on best value methodology. So the IAD is not completely, but lined up pretty well with what the cities do in that regard. Comment 9, that illustrates the requirement that cities have to competitively solicit public construction projects in excess of $5,000. Again, in contrast, IAD will use some form of competition on all contracts in excess of $5,000, not just those involving public construction. Comment 10 concerns the use of specifications requiring brand name products. Under the California Public Contracts Code, cities cannot include specifications in a contract for a public works contract project that requires the use of a specific brand or product, except in very limited circumstances. IAD has adopted a provision that mirrors this requirement, except that IAD will apply it on all procurements, not just those involving public construction. An example of a situation where there might be an acceptable use of a brand name might be, for instance, when we have to replace or repair a piece of our generation equipment. Typically, we have to go to GE or Siemens for that type of equipment. So that's a situation where it makes sense when you're trying to match parts. And there are some other limited circumstances where branding or brand name specifications are acceptable. So we've more or less we've mirrored the city in that regard as well. Comment 11 highlights a provision in the IAD procurement policy that allows the purchasing agent to sole source procurements involving less than $50,000 when competitive procurement is contrary to the public interest. That is actually a rule of law that comes from case law that's applicable to cities. The case is called Gaydon versus Pasadena Redevelopment Agency. And that case, I think, stands for the proposition that there are always certain situations, unique situations that can arise when the competitive bidding is not possible, when it's impractical to do so. So there is some authority for deviating from those rules when the facts warrant. Comment 12 deals with the procurement of professional services. With cities, the procurement of professional services are generally exempt from the competitive solicitation requirements applicable to public construction projects wherein the city has to award to the lowest responsible bidder. As with cities, IAD exempts professional services from competitive solicitation requirements. Selection for professional services will now be performed based upon pre-qualification procedures that are to be developed by staff. Comment 13, and this is the last comment on Policy 3101. This addresses procurements in emergency situations. An emergency is generally defined as a sudden, unexpected occurrence that poses a clear and imminent danger requiring immediate action to prevent or mitigate the loss or impairment of life, health, property, or essential public services. And as you might expect, in those types of situations, a city, on a vote of 4/5 of the governing body, can make a finding of an emergency situation, and in those circumstances need not abide by the competitive procurement requirements. It makes sense because in an emergency you need to procure what you need in order to prevent further losses. So IID under this policy has adopted a similar rule. In contrast to cities which completely eliminate the requirement for competition in any emergency procurement situation, IID has nevertheless required competitive solicitation to the extent practical. Those are my comments on 3101. I'll go.
Let me ask.
Sure.
You want to see if anybody has any questions before we move on to the other one?
Just one question, Vance. Can you explain why, although Article 35 applies to irrigation districts, you didn't compare us to that article?
Well, if I'm understanding your question correctly, the reason that I didn't do the comparison of the IID policy against the sections applicable to irrigation districts in the Public Contracts Code is because the public sentiment, I think, is against that. I think people want to see some more flexibility in the public procurement.
But just so it's clear, the reason we didn't compare to 35 is because 35 basically excludes irrigation districts from most of the requirements that we are comparing to.
Yes.
Which is the city section. I
That's
just didn't want
correct.
that to be misleading and that you picked the wrong section.
No, absolutely. That's very true. The situation wherein IID as an irrigation district is legally obligated to award to the lowest responsible bidder is a very limited circumstance. It's only when the works at issue are paid for by bonds or for limited assessment. And what we've done is we've expanded in this policy our obligation to award to the lowest responsible bidder to any situation where, of course, the works are paid for through bond or limited assessment, but also on all sealed bids, so that we're going to be evaluating a lot more individual contracts on the basis of those rules. I hope that answers the question.
Okay, is there any further questions from the public on this first 3101 that Vance went through? Okay, Vance. But any questions from the board at this point? We can come back.
Mr. Taylor,
Yes, sir.
if a bid is awarded to a responsible bidder, does the IID have the authority to remove or substitute a subcontractor, or is that the responsibility of the contractor, the responsible bidder?
That's a good question, and it's not one that I know off the top of my head, but I know that we routinely will place restrictions in, for instance, the RFP, the solicitation documents.
Yeah, I'm talking about after the awarding.
Okay.
Okay, so if, let's say that maybe the quality of work's not being performed by the sub, is that an item that where we bring forward to the contractor and say this isn't acceptable? Or do we retain the right to remove that subcontractor and place another one?
I think that may be an issue of whatever the contract says on the particular transaction.
And what the RFP says. I mean, some of our RFPs may be specific about subs. It's obviously, it may be a breach of contract at that point because there's a quality problem, and in the context of addressing the breach. But do we have the right to just point down and say you need to remove that sub? I don't think so unless it's something that we required in our RFP. I mean, are we missing something on that?
And I'm not saying it all.
I mean, is that
I
something
prefer
that
to
you
do
want?
that later with you. But, I think there needs to be some type of clarification whose responsibility it is, whether we set it up with a contractor and say this isn't working, how we remove them, but it just shouldn't be because of a preference of
No, I agree.
the IID.
I don't think we have a right to go past our relationship with the contractor unless there's a problem and it was either specific to the RFP or it's related to the contract. I mean, if there's a specific situation you know about, we can talk about that later, but
we
no.
probably should.
No, we don't have the right unless it ties into a contract issue or an RFP issue.
Okay, thank you.
Any other board member comments? Okay, Vance, go on into the
Okay, I will.
3130.
Certainly. I will move into Policy and Procedure 3130. And this is the policy that specifically addresses competitive procurements. Comment 1, we sort of already got into in the review of 3101, and this is the issue with regard to brand naming. Again, the rule for cities is that specifications requiring the use of brand name products may only be used in very limited circumstances. And as I stated previously, IID has adopted a rule that mirrors that of the cities. The second comment addresses pre-qualification of vendors. One of the things that the public had asked for in connection with the revision of the IID procurement policy was a process whereby vendors could be pre-qualified to do district work. Cities and IID are governed by the same rule with regard to this issue and may adopt pre-qualification of vendors pursuant to California Public Contracts Code Section 20101. Therefore, IID has included a provision allowing for such vendor pre-qualification in connection with district contracts. Comment 3 deals with mandatory job walks. Where a public agency has a mandatory job walk requirement in connection with a solicitation for the construction of public works, the agency cannot hold a job walk until at least 5 calendar days have passed since the initial publication of the solicitation. Both cities and IID must comply with this provision of law. Actually, we had to change that from 4 to 5 days when we ran across this provision. So that's one of the changes that we'll be recommending that get made. Comment 4 concerns the process to be followed when solicitation documents on a public project have been materially changed after their issuance. Pursuant to California Public Contract Code Section 4104.5, both cities and IID are required to extend by at least 72 hours the deadline for the submission of bids on any solicitation for a public works project where a material change is made to the solicitation documents. The IID rule is actually a little broader in that it applies to both public work type projects and any other type of solicitation. So the long and the short of that one is that if we make material changes to solicitation documents after their issuance, consistent with 4104.5, we're going to allow, or we're going to extend the submission deadline by at least 72 hours. Comment 5, this concerns the public notice requirement for solicitations. Cities are required to give at least 10 days public notice prior to the opening of bids under California Public Contract Code Section 20164. IID has adopted essentially the same rule with regard to public bid notice. Comment 6 concerns the amount of retention that can be held back on a public construction contract to ensure that all subcontractors are paid. IID and cities have to follow the same rule. They're allowed to retain no more than 5% of the value of the contract, and that rule is contained in Public Contracts Code Section 7201. So IID and the cities are doing the same, are approaching that the same way. Comment 7 concerns the rejection of bids. Under Public Contract Code Section 20166, cities have the discretion to reject one or more bids and resolicit the project if no satisfactory bids are received. IID has adopted essentially the same rule followed by cities in this regard. Comment 8 concerns local preference, and I think this is certainly an important issue for people here locally. Cities, it's important to note, when awarding a public project, are required to give the contract to the lowest responsive responsible bidder. Now, case law has established that because cities are required to award to the lowest responsive responsible bidder, cities cannot give a local preference in connection with the award of public contracts for public works. Now, IID is not, as we've said earlier, required to award to the lowest responsive responsible bidder, except when the contract is for public works that are paid for by bonds or through limited assessment. Therefore, IID is not necessarily bound to follow the case law that's applicable to cities. Thus, despite that IID will be using the lowest responsible bidder methodology on all sealed bids, IID will nevertheless be offering a form of local vendor preference. So that will remain. Comment 9. This concerns the process by which IID will evaluate all sealed bids. Now, sealed bids are typically used on the procurement of materials, supplies, equipment, and public construction projects that have a defined scope, specifications, and schedule. Generally, cities must award any public project in excess of $5,000 to the lowest responsible bidder. Although IID is not legally required to award to the lowest responsible bidder, except when a public works project is paid for with bonds or through limited assessment, IID has nevertheless opted to award to the lowest responsible bidder on all sealed bids. I know I keep repeating that, but I think that's pretty important. That's a big change for us. Comment 10 concerns the correction of bids that have already been submitted by the contractor. I'm not going to get into the specifics of that, but I just wanted to point out that IID and the cities are required to follow the same set of rules, and those rules are under California Public Contract Code Division 2, Chapter 5. We've adopted the entirety of those rules in the policy. Comment 11 and 12 concerns the pre-qualification of district vendors. One of the things, again, that the public was very interested in seeing in connection with the latest review of the policy was a process whereby vendors could be pre-qualified for district work. Again, cities are allowed to pre-qualify bidders under the Public Contracts Code, and as with cities, IID has adopted a pre-qualification process for multi-step sealed bids. Essentially, the way that will work is that bidders will be pre-qualified to bid on a particular project. Price will not be looked at. After we develop a short list of pre-qualified vendors, then it will be essentially conducted as a sealed bid, and the award will go to the lowest responsible bidder. Only two more. Comment 13. The purpose of comment 13 is to point out that RFPs, RFQs, and QRs will still be awarded using the best value methodology. RFPs, RFQs, and QRs are most appropriate for the procurement of services and public works projects with an undefined scope, undefined specifications, or an undefined schedule. Cities. This is more or less consistent with the manner in which cities handle the solicitation of services, as cities do not have to award to the lowest responsive bidder on service contracts. Additionally, cities have the freedom to award large-scale design-build construction projects on the basis of best value pursuant to Public Contracts Code Section 20175.2. Comment 14. Concerns an appeals process, and this is another thing that I know the public was very interested in seeing in connection with the work that we did on the procurement policy. Cities have a provision of the Public Contracts Code which requires them to essentially give vendors due process. In other words, a notice of an issue and an opportunity to be heard. And basically, if a vendor on a public construction project is determined to be unresponsive to the call to solicitation, or that the vendor lacks the required level of responsibility to perform the contracted issue, the vendors are allowed to submit written materials to try and rebut this finding. Like cities, the IID has adopted an appeals process. However, the IID appeals process is not limited to findings of vendor responsiveness or responsibility. Under the IID process, any factual or legal grounds may be presented as a protest to an award and considered by the agency. That concludes my summary and comparison against cities. If there are any questions, I'll be happy to try and answer them. If I can't answer them, Lori Franks and Donna Gray are here, and I'm sure they'll be willing to help me out.
Okay, is any board comments on this 3130 for Vance?
Vance, on both of these, did you remove all reference to what was previously stated? I think there was some comment made about the last and final offer or something, where there was, I mean, the best, last,
Best-
and final is the bid that's turned in. Is that correct?
Yeah, I don't think did we do anything on that? Do you remember?
No, that came to us from the National Institute of Governmental Purchasing, which is a
confusing language.
standard practice for governmental agencies. So I don't think it was removed at all. Yeah, it's for RFPs, for formal solicitation.
I think the answer to that is no, but it's certainly something we can look at if you'd like us to.
Basically, you have a timeline from turn in your bid, and that's the final bid. Is that correct?
Under that clause, you have the vendors have the ability to modify their bid. Or, it's not a bid, it's the proposal response.
If she's going to talk, make her come up to the mic.
That is one way that
Yeah, Donna, why don't you come up to the mic if you don't mind, please?
Donna Gray, purchasing agent. I'm certainly not an expert on that process. This was one that the National Institute of Governmental Purchasing gave to us as part of the review. They explained that it is a way in which you can, as a governmental agency, get a better price for the services or the product that you are bidding or, soliciting out. So. That wasn't anything that we had prior to this. But
Well, I just saw it in one of these documents prior. It was
but
in the document.
it came from NIGP.
Okay, but we're not going with that. Is that correct?
They left that because it is a tool that other agencies use to get the best price on their
Well,
solicitations.
if I was putting in a quote, why would I give you my best quote if I get to modify it?
It isn't a matter of you. I mean, you still are taking your chances if you are putting in your best and final offer, and it isn't in a sealed bid. It's in the proposal.
When they submit their bids on it, would they know that this was a situation
Yeah.
where there might be a best and final
If
offer?
it was going to be a solicitation that we were employing that technique, that would be explained in the solicitation. So everyone would know at the beginning, before they even put in any work on a solicitation, that this was going to be handled in this
is
manner.
that open to everybody to see what the bid is, and then do they get a chance for a counter? Or, I mean,
Is there an instance in which you can conceive of IID using a method like that?
At this point in time, like I said, I've never employed it, and I haven't had any chance to talk to any other of the governmental contacts that I have in procurement. So I can't give you an example at this point in time.
Sounds like an easy one. We can strike it.
okay.
It's just in the toolbox. They have no intention.
Laura, did you have a question? Any comments?
Just as an example, it wouldn't be on a sealed bid in any way, shape, or form. When NIGP is referring to my previous experience, when you talk about best and final, is when you're going out for an RFP, you're doing a proposal, the vendor is submitting a method to solve the problem. You're comparing it to 3 different methods. If you want to add a warranty on it, you would contact the vendor on their proposal, and you're saying, okay, can you provide me with an additional 5 years of a warranty? Then they would submit their new proposal, including that type of a warranty. Would never be on a sealed bid as far as we're concerned regarding that. It's talking about a formal solicitation, which would be an RFP and RFQ, not a sealed bid, which is the price is final as soon as we open the package.
Okay, further questions from the board?
So this today, what we're hearing and seeing today is Vance's comparison to another code, as the policy stood before.
This is Vance attempting to marry these 2 policies with the Public Contracts Code.
Is this best, last, and final proposal?
This is
Our policy goes way beyond that, but the effort was that there's been a lot of discussion about whether are you doing what's provided in the Public Contracts Code. Well, unfortunately, there's a lot of different things provided in the Public Contracts Code to all different agencies, and irrigation districts are not required of much. So we picked an agency that more is required of, that's like us, and tried to show you that, in fact, we're doing everything in the Public Contracts Code and more. And that was the intent, just to say, look, here's what we know, what we have. There's a bunch of stuff in our policy that has no analog in the Public Contracts Code.
Any further questions from the board before I turn it over to the public?
And the pre-qualification status that's been so much discussion, could you go over that again? Any changes or comparisons you found in that of the other code as compared to the new one that the IID is proposing?
Well, basically what the statute says is that cities have the ability to set up a process whereby they pre-qualify vendors to do work. They don't really get into how you're supposed to do it. They just say that you can do that. And that's more or less what the IID policy says as well. We've just established we really haven't established the procedures yet. I think that will come in an SOP down the road, but we've included a provision that will allow us to open that door and to develop those processes and procedures as we move forward.
Any other board comments? Oscar, yeah, you're waiting, then I think Aaron's behind you, but go ahead, Oscar. You have to go to the podium.
Oscar Gonzalez, I'd like for IID to be inclusive. I would like for them to include women and minorities. When I used to be the contract officer for contract compliance for the county, many, many years ago, about 30, the state also has them. My cousin, 2 years ago, competed for a contract, bread, bologna. That's what they eat every day at lunch. He was able to get a contract in Calipat. The state has a procedure, and I'm sure it's inclusive with the law, where they give preference to minorities and women, because you know that historically it's been a boys' club or men's club where they compete, and the state has state prisons statewide have preference for women and minorities. And I would like IID to be inclusive because it's not illegal, and they give preference to women and minorities, especially Caucasian women, and any wherever, for that matter, Mexican American or Native American. I would like for this gentleman to include that in IID because we have many minority and women here that could readily compete with men. So I would like for him to research that and bring back a policy recommendation, because this thing has been for many, many years. And when I was the affirmative action officer at age 22, and I was also the contract compliance officer, and I know it's legal to give preference to females and minorities. Thank you.
Thank you, Oscar. Aaron Miola.
Good afternoon, Erin Moyola, Co-Lab Imperial County. It's so interesting to me that I spent the weekend, we were in San Diego just by chance, and we don't have TV at home, so I had TV in the hotel room, and it was a lot of fun. And I watched a lot of news, a lot of the news, and really caught up. And on the news this weekend was everything about the GSA scandal. And it talked all about how, very obviously these public officials did not have a care for public funds and how they were being misused and treated. So interesting to me today to walk into this IID board meeting and have the IID, who has a known track record of deep corruption to the tune of tens of millions of dollars a year on this contract bidding issue, try to work every single angle and find every different contract bidding policy out there under the sun to make this a special fit for the IID, instead of this board saying enough is enough, and we want you guys to move towards the most stringent and the most conservative contract bidding policy that you can put together. Enough of this trying to weasel our way out of a conservative contract bidding policy. I mean, we have Jeff here who's doing us a favor by not just following the water code as he sees it, by not trotting out the water code. Come on, guys. You guys know that there's corruption in this. I've been in these meetings for 10 years. I've seen every year people come up to you and complain about this process. You know that there's a problem. But I'm getting to the point where I really believe that this continues because a majority of this board actually depends on this corruption to continue. And I honestly believe that. And I really think that the facts are going to come out soon on this issue. And I hope that this board has the guts today. I would hope that there would be a 5-0 push right now, and everybody's comment would be, you come back to us with the most conservative, stringent contract bidding policy that you can bring to us, and that you would put it forward. Because you do have a history of corruption, and you know it.
Thank you, Aaron. Anybody else want to speak to this issue? Okay, Kevin, what do you want to do now? This is an informational item. We spent a tremendous amount of time on this, and I know we've had input from the outside, and I think we've been doing our due diligence on this. So, how do you want to handle this thing for coming back to action, or how do you want to handle this issue?
Well, I think that it's the next step would be for us to bring it to the board for some sort of definitive action. I would ask Ms. Miola and others to refrain from accusing IID of corruption. I think that corruption is a very strong word, and it certainly isn't warranted based on what we've done since that Enon contract in order to get these two policies to a place where they reflected best business practices and the input that we've solicited from you. So, with all due respect, I think that corruption is I mean, I've heard it repeatedly over many months, and I would ask that you refrain from using it.
Okay, the one comment that I would make about what's going on here is, I know with Mrs. Miola coming up here and representing Imperial Valley First, CoLab, Imperial Valley Vegetable Growers, it's very unfortunate, I think, that especially when she says that the majority of this board is corrupt. And I assume that she's speaking about the three here that have been voting for the people and trying to stay on what's doing right, because it's election time, and we know that Imperial Valley First is going after two of the board members that are up for election, the incumbents, Dr. Mendoza and myself, and that's fine. That's the Democratic policy. Anybody can do what they want, but to openly say that the board's corrupt and the majority of the members are corrupt is going way over the top. And it all comes down to the water. They want to change the makeup of this board so they can get control of the water. And water's a public resource, and the water needs to remain a public resource. So it's going to get hot and heavy. And we've tried to work with CoLab and tried to take care of some of these issues, but some people just want to keep beating on us, saying we're corrupt and that we're not following the proper procedures and et cetera. So I'm going to start speaking out how I feel about things, because I've taken enough beating on the blogs. The Imperial Valley Press, thank God they stopped the blogs. That was total character assassination by about 3 to 4 people who are IAD haters. So we'll eventually get there, and hopefully that the people will decide who they want sitting up here on this board. Does anybody else have any comments?
Yeah, I want to speak up.
Sure, go ahead.
I mean, since we're all campaigning here, Mr. Kelly, prior to you coming in as a general manager, I had met with numerous contractors that were doing business with the IID and wished to continue doing business. But they were very concerned about the position that they were being put into, some of the things that they were being asked to do, and they didn't want to get into trouble. I brought it forward in closed session to this board. I talked to the prior general managers about it. Now, maybe the one term is a little tough, but irregularities, yes. And I think that we owe it to the public. We're talking about their money. This isn't an issue about water, public resource, or any other campaign speech. This is about public funds that we're all accountable for. And whatever it takes to get this squared up, to get the public trust back, we need to do it. We can still operate. If we have bids come in, or we have bidders that we know cannot handle the job or whatever, there's provisions in which we can dissolve those contracts or deny those contracts. But let's get it cleaned up. We've been dealing with this for years. And, you know, I'm not saying any board members involved in it. I'm just saying that we've had complaints from the public, and whenever they come up themselves personally and bring it up and concern and give evidence that's been passed on to prior general managers, then it's time to do something.
Director Hanks, there's no question that this is a policy. These are policies that are in need of reform and refurbishment, and trying to bring it into accord with the Public Contracts Code seemed like a useful exercise. I asked Mr. Taylor to do that. He found it to be very difficult. Where he could find accord, he did try to incorporate it into the two documents. But you'll get no quarrel with me about our process needing to be fixed. I merely object to that loaded term of corruption.
Okay, any other, Ms. Miola, you had a question or a comment?
I want to say two things. One thing is, I would love for the IID to prove to me that it's not corruption, and there's a way that you can do that. Put your auditing staff, have them review the last 2 to 5 years of contracts, come back and tell us what percentage of time you are foregoing the low bidder and taking a higher bidder, and also tell us how much money you've left on the table by not taking a low bidder. I'd love to see that number, and I'd love to see the backup information, because as you know, that's what I was looking for, and I was going to go to my board and say, well, these are the numbers. I can't do that because you gave me incomplete and inaccurate data. I would have loved to have had that, and I could have told you right now what those numbers were, but you didn't give me the data to use it, or 3 professionals who looked at it and said that it was unusable. So you guys, put your auditing staff on it. Come back in 30 days and tell me I'm wrong, and you know what? I'll say I'm wrong. I'd love to see those numbers. And then the second thing is, and I thought about this as I walked away and I saw Donna and Lori, I want to say something. Your staff is not at fault here. This is not a staff issue. They are good staff. They call us back. They are helpful. They are following the policy that you have set in place. This is a board issue.
Yep.
I have a comment.
Laura, as soon as, wait a moment. Laura, did you want to say something?
Did you want to address?
Laura, did you want to make a comment?
Okay. Lori Franks, contract administrator for the district, and like everyone here, I take exception to the word corruption. The CoLab has requested public record acts and information. I personally spent a lot of time and energy compiling all the information, worked with our legal department to release some of the information that we had withheld previously as confidential. I have provided all of the information that was requested by the CoLab, in addition to preparing spreadsheets and additional information. I have returned calls. I have been waiting for a call back regarding a specific solicitation and have not received calls back on it. Little upset, apologize for that, but the fact is that I've always been open, and when people talk about a specific solicitation, I've always been willing to sit down with them and go over it with them. We're doing the best that we can to improve the process, and if there's a specific suggestion to improve the process, we're more than happy to take that suggestion and see how we can improve it and how we can implement it. like we will be in the new policy regarding sealed bids, lowest responsible bidder. The fact that we are having accusations, and with all the information, when I went back 2 years and I have provided the results from the last 2 years to the CoLab for their review, and no specific one item has been brought forward as far as an issue or as far as requesting or in any impropriety or anything has been brought to my attention or that I am aware of. And so I do take exception to the correction statement.
Okay, thank you. Director Sanchez?
Kevin, having experienced my own experience with the district 7 years ago when the Western farmland were being sold, I wasn't able to put a bid for my title company before I was on this board to be able to give you an or give us an opportunity to compete for the title work. But at the same time, we have a new policy here that will hopefully tackle a lot of those issues. So whatever has happened in the past, I've experienced it, which Aaron has spoken about. But I see a policy to move forward now that I'm on the board to continue to try to tackle that, and knowing that it will never be perfect. So, and we always hope that it will be perfect, and we hope that this one will be perfect. And if it's not, then in a year we're going to come back and change it again and change it again. My question is, will this new policy improve and cover all the aspects, or do you believe there might be loopholes that we don't even know about yet?
An organization as large and diverse as this one, with as many needs as it has and as many solicitations as it makes, I can't speak to the breadth and depth of IID over the course of a year. I can only say that if it were possible to recommend to your board that we simply adopt the Public Contracts Code and be done with it, then I wouldn't hesitate to do it. I'm told by Mr. Taylor and by Purchasing and Contracts that it simply isn't possible to do. So what we've tried to do is to give you what we think represents the best and most ethical course.
You could adopt the Public Contracts Code, but you're only going to get a fraction of what we have. If you want to do that and you want to delete all the stuff we have that's in addition to the Public Contracts Code, you can do that. The point here was we've been criticized that we're not following the Public Contracts Code. We go way past everything that's in the Public Contracts Code. If you want us to follow the Public Contracts Code, we can. You can just say, follow these sections of the Public Contracts Code. That's your policy. That's fine. The point here was to talk about our policy, which is the one thing that nobody's talking about. If people in the public think there's something wrong with the policy or it can be approved, let us know.
Okay, Mr. Taylor, you have anything else?
No, sir.
Any of the board members have anything?
Yeah, I participated on the committee that did the rough draft review of these two different policies. I didn't make all the meetings, but I think I made a majority of them. And it was a very interesting exercise, and it took a long time. And there was a lot of work put in. That doesn't necessarily mean that what we've come up with is easier understood. It's lengthier and takes in more subject matter and more codes and more policy. But at the end of the day, do we have something that answers the public's and the IID's needs for understanding and getting the job done in a better way? And even though I participated in the committee, I wanted to, I spoke up a few times and we talked about it. That doesn't necessarily mean that by being on that committee, I'm endorsing this policy. I'm learning and going through the process, and I don't think it is perfect. To move forward with it as an action, I'm not quite sure if that's the right way to go at this time, Mr. Kelly. It's long, it's lengthy. There's a lot of language in there. Some might even call it fancy language that can be interpreted. And we were dealing with humans here that can interpret anything. So the important thing is the board's hearing this concern and staff's hearing this concern, and that we get something put together that satisfies.
Director
Yeah.
Mendoza?
Mr. Cowley, what is your recommendation? To bring this back for action at the next meeting, or want to wait the more time to review it some more?
We'll come back to you
Okay.
at an appropriate time.
All right.
Okay, thank you. We'll move on to item number 2, which is water general matters. Mr. Silva?
Yes. We are in the middle of our high flow period. As a matter of fact, today in our staff meeting, I was told that we ran 2,600 CFS on the High Line, which is a maximum that can run last Friday. We have a lot of carryovers, and so we hope that if you get any complaints from our water users, they are real. I mean, we are running up to 5 and 6 days of carryover, but our canals are at capacity. So please bear with us. We're doing everything that we can right now to go through this time period, which happens pretty much every year. The other thing is that we've been getting some reports from the Bureau regarding our water use this year, and we are running about 65,000 over our submitted order. But just remember that we don't have the fallowing program yet. So really, I'm not sure what that really means right now. So until we get into the fallowing period in the middle of the year, those numbers may not be indicative of what we'll have at the end of the year. That's all I have.
Any questions for Mr. Silva? Okay, thank you, Jesse.
Thank you.
We'll move on to item number 3, review of major work authorization covering the repairs to the central drain number 6 pipeline. It's on page 54. Ismail is not here.
He's researching the policy.
Jesse, you want to handle that? Well, I've got it. It's what it is. The background is the Central Drain Number 6 pipeline project consists of replacement of approximately 1/4 mile reach of existing pipeline south of Crookshank Road. Project is located east of the city of El Centro, approximately 1/2 mile west of Highway 111 and just east of Cannon Road. Central Drain Number 6 pipeline was installed in 1964, has collapsed in multiple locations, and now needs to be replaced. New pipeline will ensure that the district continues to provide adequate drainage service to its customers. Financial impact is the cost estimate for the project is $299,000, is included in the 2011 design and 2012 capital budgets construction for concrete lining. The recommendation is the board will approve this MWA at the April 17, 2012 meeting. So that'll be brought back.
Mr. Silva, would this project be done internally or would be contracted out?
Right now, we're talking about doing it.
Okay.
Any questions on the, Mr. Stills, you have a comment on this?
Well, I'm just going to step up and say
Yeah,
reviewed this.
come on up.
We've reviewed this thoroughly. We've been working with the water department. We really think this is necessary to move forward. So,
Any board member comments?
Bring it back on the 17th?
Okay, thank you, Carl. Thank you, Jesse.
Thank you.
Energy number 4, general matters, Mr. Ivy.
President Minville, directors, I'm pleased to announce that we have the Yucca generating station back online as of last Saturday, up into full production. Recall that's the one that had the collapse of the cooling towers, and APS and the contractors did a fantastic job of getting that back online, very timely. Should certainly use that in the summertime. Next week, I'll be bringing you an informational presentation on the San Juan mine reclamation proposals. This is something that's apparently been in the works since 2006, 2007, but it'll be a more complete presentation come next week. That's all the comments I have.
Okay, any questions for Mr. Ivy?
That's the San Juan, that's the energy, you said mining proposal, or is that the energy, the
It's the,
generating facility?
for the mine itself, we have to have a reclamation plan and have it funded so that we can actually get it back to its natural state by like 2050.
Okay, Mr. Benson, you have a question?
Steve Benson Brawley. I just had a question. I was reading in the paper that the nuclear power plants are offline and they don't know when that's going to come back on, and there might be a transmission issue for the summer coming up within San Diego to LA, and how that might affect the grid if we're looking at rolling blackouts or what type of issue will become.
there is a lot of concern with the San Onofre nuclear generating station not being able to come back online in the summertime. There have been some power flow simulations that we've done for the region, and it's very possible to recreate the scenario for the September 8th power outage that affected the entire region. But what we're looking at is making sure that we're dispatching the proper amounts of units that were not running at that point in time, and trying to ensure that in fact will not happen. But it's very easy to replicate the September 8th event based on the scenarios that we're seeing. But we have generating units inside of Arizona's territory, perhaps in WAPA's, and certainly in our own. And then some of the generators that are south of the border that either weren't running or were spun back quite a bit at that point in time. So we're still looking at it, but it's my sense we'll be able to weather that, along with the facilities that the ISO is looking to bring back out of mothballs. Mm-hmm. So between all of that, I think we'll have a plan that will work.
Now, is there any renewable that's coming online, like baseload, or is everything just renewable, kind of a peak load scenario? As far as
Right. The majority of the things that are coming online in the short term would be the renewable, like solar type facilities, and most of the base load is online already.
Okay. So geothermal or something would be something that would replace it.
Like the Hudson Ranch facility, it came on in early March, I guess, and so it's online now and running. So we're counting on that.
Okay. Is the IID working with Cal ISO as far as the whole system, or how are we integrating with them?
Well, based on what we learned from the September 8th power outage, is that we could do a better job of talking to each other. And so we certainly are working together to try to make sure that the scenarios that we're putting forward are true scenarios based on what we know about our own systems. We're sharing more openly what the system models look like. So I would say that we've probably communicated better now than we have in quite some time.
Okay, thanks.
Thank you, Mr. Benson. Okay, any other comments on this? Okay, then we're going to move on to item number 5, review a request for proposal number 878, installation of energy efficiency equipment for small commercial businesses. And Diana Rosas is going to handle that.
Good afternoon, President Menville and members of the board. I'm Diana Rosas, Operations Supervisor of the Energy Management Strategic Marketing Unit. I will be giving you a brief overview of our 2012 Open for Business program and proposed award to RFP 878. This program is a continuation of the direct install program offered during 2011, which targets small businesses with a monthly energy demand of 100 kW or less. The goal of the program is to assist these businesses in reducing operational costs, as well as promote energy efficiency and increase education and awareness amongst our customers. Each qualified customer will receive up to $2,500 worth of installations of energy efficiency measures. These include lighting, gaskets, motion sensors. Each measures are categorized as lighting, cooling, and refrigeration. We have those 3 categories and several measures below those categories. Anticipated energy savings for this program are approximately 3,100 megawatt hours, or roughly 20% of our 2012 energy savings target. IID achieved estimated savings of 3,065 megawatt hours during the 2011 program last year. We had over 990 participants last year for this program. The solicitation attracted 6 respondents, which were evaluated based on overall cost effectiveness. Synergy Companies was the lowest bidder and based on the best accumulative evaluation score, confirmed by our cost effectiveness evaluation tool. As such, staff recommends approval of RFP 878, awarding the contract to Synergy's Company for our 2012 Open for Business Direct Install program.
Okay, any comments from the board?
This is the information will come back for action next week?
Yes, correct.
Okay. All right, thank you very much, Diana. Kevin, do you want to take a quick break now, or you want to go through a few other items here?
5 minutes would be great.
Okay, we'll take a quick break. We'll come back in 5 minutes or so. Okay, we're going to move into action. Item number 6, page 74, disbursements through local entity for competitive mitigation program 2010. And Vince, you're up, and Gustavo's there with you, so go ahead.
Good afternoon. We're going to pick up where we left off at the last meeting. Before I have Gustavo come up, I just want to give you a little update. We did approve the non-competitive program for 2012 last week. If you remember, we developed a little computer program, so it's being installed on thumb drives now, and then it gets protected so nobody can mess with it. As soon as we have those back, which we're hoping will be tomorrow, we will roll out this program, and you'll probably see something in the paper on Sunday about it. So it is moving forward. We have a couple of housekeeping items on the 2008 program, and also some funding requests from the 2010 that Gustavo is going to bring forward right now.
Good afternoon, Mr. President, board members. We'd like to start off with the 2008 program. We have 5 items that we'd like to bring to your attention, some of them for purely information, some others for action on your part. First of all is Arbor. Arbor has completed their program in 2008. There are remaining funds in the amount of $20,873. They initially requested to be able to utilize those funds into their 2010 program. After discussions with them, they came back and requested that money be returned back into the IID. Last week, we received a call from them saying that the director of that program, Marta Anaya, would be out of the city, and she wanted that those funds to be returned back to the IID before she left the city. That money was picked up and is now in the hands of the IID, so this is purely informational item. As far as items 2 and 3 relate to Imperial Valley College, we received a request letter from IVC pertaining to their 2008 program. And we separated the request that's in that letter into 2 parts, item 2 and item 3, because they are somewhat distinct, but at the end you will see that they do come back together. So we're going to start off with the second item. Item 2, IVC has once again is in the process of terminating their program. The performance period of the program has been completed, and there is a total amount of $58,907 left over in unspent funds. The source of these funds is that 2 entities that were approved for loans did not utilize the funds, so that totaled $50,000, and then there's one other program that did not receive the entire $25,000, so that comes out to $58,000. Now, as far as the request that IBC has regarding that $58,000 is that they be allowed to return a total of $37,000 and retain $21,300 for operational costs. Now, our recommendation, as you have it before you, is that this not be authorized. That recommendation is based on the manner in which the request was presented and based on the information that they submitted in their proposal. However, we had discussed this within our group, and we do have some suggestion that perhaps may meet IBC's interest and also retain the integrity of the program.
You're going to work that out with Mr. Silva, right?
Yes, we hope to meet with them.
They would partner with another entity and to facilitate the use of these funds and the training?
Well, we are recommending, if I can just very quickly, we are still recommending that the $58,000 be returned to the IID, and IBC is requesting $21,000 to be used for operational costs. Now, there is a loan that they do have out at this moment, which, if paid back, would return $25,000. Their proposal never states what would happen with any program income that comes back into the program. What we are suggesting is that IBC look at utilizing that $25,000 coming back from that program for whatever expense they have within the program. That will meet their needs while also returning the unspent funds back to the IIT in their entirety.
That's fine. And Mr. Silva's here, and I think he's going to get together with you and Vince and get things
We hope to
worked
discuss
out.
this and see if that could be solved.
Is that fine with you, Mr. Silva? Okay.
The second item in regarding IBCs is basically, even though they are separate requests, they are piggybacked one on the other, because what gets resolved on the first item will impact the second item. So if it can be resolved, if the first item can be resolved and program comes to termination, then there's no need to relinquish the program. It just closes out. So they are one based on the other.
Okay.
Going forward into item 4, the destination and return funds. If IBC does return the full funds of $58,000 plus the $20,000 from Arbor, there's $70,000 that will be returned from the 2008 program back to the IID. We are bringing this to your for your information, and also asking for your advice as to what should be done with these funds. Our recommendation is that we bring something to you if there are any programs out there at this moment of entities that are in dire needs of funds. Perhaps we can bring back a list of those and qualify them for you, or if you determine that they should be returned back to the program, dispersed into the next following year's program, that will be up to you.
You know, if you select programs without doing an RFP, that I wouldn't be comfortable with that. If there's any funds left over, as one board member, I'd rather pull them with the next year funding, so that way when they do the RFP, everybody has a fair chance of competing for the funds.
Absolutely. Those options are up to you. Right.
Well, I mean, that's just one board member. That's
Yes. As far as the last item, the 2008 grant program closings, we are sending out letters to the other grantees advising that the performance period has concluded, and based on the RFP, they are required to provide us with a closing report. We will verify the outcomes that were attained throughout the program, verify the expenditures, and close out the program, and then it will be subject to whatever review that the IID wants to do over those programs. So that is the 2008 program. Going into 2010 program, we have 6 items for your review. You have the information there before you. First of all, the first item is related to the Imperial Valley Food Bank. In January of this year, the food bank came back and asked for a second disbursement request. That was approved and that funds were dispersed. Unfortunately, there was a controversy or a discrepancy as to the application of the process that's within the RFP. We have now gone back and reviewed that process, as we do continuously in our group, that we go back and review the process. And we have found that all disbursements must come to the board for your approval. So we're coming back retroactively to inform you that those funds were released to the food bank. They did meet all their disbursement requirements. They did have all their expenditures verified. And for the purpose, we are letting you know that we took a misstep in that. There was controversy as to how the RFP was interpreted. We have gone back and verified that. And from this point forward, all disbursements will come directly to you for your acknowledgement and approval.
Okay, thank you.
The second, third, and sixth items, JCS Construction Imperial Valley Occupational Program and Imperial Valley Food Bank, are disbursement requests. Each one of these have met all their outcomes within their previous disbursement cycle. JC is coming back for their third disbursement in the amount of $44,000. Imperial Valley Occupational Program is coming back for their second disbursement in the amount of $83,000. Imperial Valley Food Bank is coming back for their third disbursement in $83,000. We have verified their outcomes and their expenditures, and they are in line with what they propose, and we find no issues which should retain or disallow their request for disbursement. That is an action item, and we are requesting your approval to release those funds. The fourth item, City of El Centro, is also an action item. In February of this year, if I go back, the award was made to the City of El Centro Redevelopment Agency. That's the way the award letter reads. As of February of this year, the redevelopment agencies have been disbanded by an action taken by the governor's office. The City of El Centro presented a request to bring the program into compliance to make sure everything is okay, in which they are requesting that the grantee appear only as the City of El Centro. The mayor of the City of El Centro, Cedella Sanders, has submitted a letter in which the City of El Centro directly assumes all responsibility with regard to this grant that was previously assigned to redevelopment agency. It is more a house cleaning issue of keeping things the way they should be.
But the program is the same.
The program is the same outcomes. The timeline will be adjusted because of the time that we have spent on this item, but everything is exactly the same. The amount of money that the City of El Centro committed is still the same. The outcomes are exactly the same. The only thing is that we will modify the award letter to reflect that it is the City of El Centro.
Not the redevelopment agency.
Absolutely, yes.
Okay. That's it then, huh?
The last one is the program progress update on the 2010 programs. Everything up to now is without any issue. We provide you information as to how much funds have been provided to each one of these entities. We anticipate them coming back for their next disbursement. Up to now, we have not found any major issue on any one of these programs.
Okay. Mr. President, I'd like to approve the provision of the grant awards under the 2010 competitive program.
Is there a second? I'll second it. Any discussion by the board?
Yeah, are we going to take action on 2008 too? Are they not?
Well, the recommendation says.
We can take that separately.
Well, what I would ask is that we take the Imperial Valley College separate.
That's fine. For 2008, you're talking about.
Well, okay, my motion is regarding the 2010 competitive grant
Right.
program.
Okay, right now, there's an action item for 2010 with a second. So is there any further discussion? Okay, please vote on that.
Yeah.
Okay, thank you. Then we'll move over to 2008, and Director Hanks, you wanted to take Pearl Valley College separate.
I need a little bit of clarification from, if I could address Mr. Silva. He left?
He left.
Oh, okay. Well, what I was concerned with, I know that all the schools are having financial problems. If they're in a situation where they're in a match or something that is creating undue financial burden, then I would suggest letting them out and return the lower amount if that's the case. If that is the case, I would ask that maybe the president of the college send the general manager a letter.
That is the case, or it was a couple of months ago. Mr. Silva contacted me and said that that process had become too burdensome on IVC.
Yeah,
and I think I referred it to the legal department.
If I can provide a little bit more information.
Yeah, would you and then Vince, I think you guys have had a sidebar conversation with Mr. Silva. If you want to explain that, please.
The way the program was established by IVC is that it would start, there would be 12 loans awarded to local businesses. Over a time period, if they met certain obligations, those loans will be converted into grants. There were a total of 12 loans given out. 9 of those were converted to grants. There is one that is one loan that was declared in the individual just took off with the money. But there's one loan that, although they have met the outcomes, part of the requirement to convert into a grant was to make their monthly payments on time during a 6-month period. They did not meet that requirement. That loan is on the books for 5 years. So IVC has a problem of continuing this program through 5 years when there is no overhead costs built into the program. If I can remind you, the grant that was awarded to IVC, there's absolutely not one penny was for overhead expenses. It was all for loans. So IVC did do a tremendous job of not building any costs into the program. Now, because the program is extending, or possibility of it being extended for 5 years, of course, we see that possibility, that need for covering some of those costs. And more so because of the issues dealing with the economy of local colleges right now. So that is why they are coming back with that need for overhead expenses.
Okay, so Director Hanks, you wanted to know about taking Imperial Valley College separate, so That's fine, then we need a motion on it, ABAR, and what do we need? Just one action item for the number one issue?
Well, I think you had some return funds you need to take action on.
Okay, you want to make that motion, Director Hanks?
Yeah, I'll make a motion that the return funds roll over to the next go-around, and then also accept the other proposals with the understanding that the general manager would meet with the college and give us a...
We'll determine how to
Okay,
dispatch
thank you.
that.
Okay, that also needs, the motion needs to include number one, which is Arbor, because it's combined with that.
Right.
Yeah. Is that in your motion as well?
Yes.
Yes.
Okay.
Okay, is there a second?
Second.
Is there any discussion? Please vote. Thank you. We'll move on to item number, thank you.
As far as 2010 program, the authorization to release funds to JCS Construction,
I thought
IVROP.
the motion was for everyone,
Was the motion for
from 1
2008?
to 6. The first one.
Oh, okay. Oh, I'm sorry.
Done. Thank you,
First
Gustavo.
one.
Thanks, Vince.
All done. Thank you.
Tina, you're up for increased contract rate from $100 to $125 for the 2012-2013 following program.
Good afternoon, Tina Shields in the Water Department. I am here to request an increase in the following program payment rate. The last time we came to you, we requested an increase from the solicitation offer of $85 to $100. We did solicit with that rate. We received over 350 applications, and to date we have received, in essence, contract commitments for over 100,000 acre-feet of water. But that's still far below what we need in order to meet the 2012 fallowing obligations, as well as catch up from last year since we did the smaller than average fallowing program. So I'd like to increase the price to $125. That will bump up the folks that are already under commitments, and then we will quickly do a resolicitation process to see who else is interested.
Okay, is there a motion to that effect? I'll move for approval. Is there a second?
Second.
Discussion.
Discussion.
Tina, we're making every effort to get this accomplished. Do we have any feedback from the Farm Bureau or WCAB or their ideas or views of this?
We are working with them on fallowing concepts that would basically change the program we have now for this current solicitation process and for the fallowing program that starts July 1st. There's simply not time. We have modified somewhat the existing program to allow for early start dates. Of the 185 contracts that we have in hand currently, my understanding is about 75 of those will be taking advantage of that early start date. So that's about 40% of the contracts. But beyond that, we're a little limited just because of timing on the changes we can do within the existing constraints. But we are discussing for future programs what changes might make them more palatable.
And the early start dates would be, what would that be compared to what we did a year ago or the last time?
Our standard program starts July 1st and goes through June 30th of the following year, so it's 6 months in each year. That was originally intended to try to accommodate farm leases, which tend to be summer to summer leases. They're not all the same date, so we couldn't find a date that made everyone happy, but that was the best stab we could do, and the fact that it's 6 months and 6 months makes our allocation of water much easier. So what we're allowing to occur right now is you can start any first of the month back to January 1st of this calendar year. So we'll be backdating those contracts and trying to get a little bit more water, primarily because when we do contracting, because we're on a mid-year to mid-year program, we get a chunk of water for that current year as well as start on the following years. And last year, because of the QSA litigation and the risk, we were only authorized to proceed with contracting for 2011 water. So we currently have no 2012 water under contract.
Yeah, so it's a 6-month mid-year cycle. We're looking at finishing up a wheat crop coming up, and the crops would be fallowed or they'd be doing tractor work during the summer, where the farmer, where the property owner now would be getting credit for fallowing. And if it only goes 6 months and there's no crop in the field, most likely the next planting date would be in the following spring. So you're confident that the wet water that we're creating is going to be accurate and will hold us in a proper position when the accounting is done?
Right. I mean, it is a calculated number based on your best available information. We've had criticism that the yields are too high that we claim. We've had the same criticism that they're too low. So we're doing the best we can on that. I think it's a very reasonable number. Some years you gain, some years you lose. Overall, on average, I think it's a pretty good estimate. To the extent that what we're doing now is taking a 12-month program and letting it be larger so it can be 13, 14, up to 18 months. Ideally, I would have liked to had a shorter term project. We're just fighting the clock right now. So that's some things we'll be looking at for next year is maybe a calendar year program. We have authorized a second year renewal for folks in the current fallowing program. That's been very successful. I will be coming back to you at some point asking about your interest in doing a second year for these participants. That allows better planning for the farm community and it reduces contracting for us, so that's helpful as well. And they have inquired about a second year, but we're just trying to get this first year right now.
Thank you.
Any other questions from the board?
Yeah,
Okay. I've got Lindsay, you're after the board. Go ahead.
Tina, on the QSA fallowing program, what's the ending date for fallowing?
2017, unless the board takes action after the state board makes decisions on whether it would allow a change in the salt and sea mitigation, that proposal would push the fallowing to end 4 years early, at least for salt and sea mitigation purposes. So that would reduce the largest component of fallowing in the last 4 years. There's 500,000 acre-feet of water purely for salt and sea mitigation. So what we're seeing right now is large stepped increases in fallowing as a result of the mitigation obligations.
Okay, on the funding for this program, what line changes are you proposing in the budget?
My
Or
guess is we'll have to
approved budget.
come back with a budget modification based on what the actual contracting is. They were budgeted at $85 an acre foot, and you'll note that the revenue for the transferred water ranges from $491 in this calendar year to
You're asking us to vote on this. Can you tell us what we're giving up to transfer these funds from? Are we talking about on-farm programs? Are we talking about systems or?
well, that's going to be a prioritization issue. You don't get the money if you don't transfer the water. So if we fail to produce the water, there will be no revenue.
I can't vote for it.
Well, I don't know how much we have right now. I'm doing the best I can with the information I have. So.
All right, then, yeah, go ahead.
It probably will come from the budget that we had. If you remember, the SAP was supposed to start this year, but we've had a delay in the awarding the RFPs, and so we're already about 5-6 months delayed. So I think that there will be enough money available in that budget category. But again, I can't.
But it's transfers, not callback money, or
no. That's where it would come first, is from that budget category there. So I think we'll be all right because we budgeted a lot for this year, but we're not going to be able to get to it. So
Okay.
hopefully that difference we'll be able to utilize for that difference between 85 and 125.
we want to make sure on that early start that the comments that Director Desert brought up, that we're okay with that. But I've got a problem with this from the standpoint the collateral impacts that these programs have on tenant farmers, on their rent, maybe even the terms of their contracts being taken back by the landowners to, we've increased the rates, and so then, with her, they have equipment, they have payments, and this really turns things upside down for them.
Right, and I don't disagree. Unfortunately, a fallowing program needs fallowed land, and it puts us in direct competition with those who want to farm in a strong ag economy.
Any other comments? Lindsay?
Lindsay Dale, Imperial County Farm Bureau. Just to respond to Director Desert's question, Farm Bureau has not been involved in this discussion officially. I know WCAB has developed a subcommittee to discuss the fallowing program, but to my knowledge, they have not met on this or discussed it. And our board members do sit on that following subcommittee, or some of our board members, so that's where Farm Bureau stands in it.
Okay, no problem. Any other board member comments? Mr. Benson?
Yeah, I just wanted to say, as an outgoing chairman of the WCAB, we did not get a chance to meet. Tina's been pretty busy. You guys keep her moving around a lot, so I guess that's good. Also, one question is, what happens when we don't get enough signups? You said we just don't transfer the water, so then that could be a rolling issue. But my feeling is, and it goes to the on-farm, if you keep raising the fallowing rates, the on-farm is going to go away. Because if I have to spend money and come out of pocket to do on-farm and you're only giving me $200, $250 an acre foot, why wouldn't I just fallow and get it all and not even have to farm? And I think it's really you're gonna see a lot of pushback. I'm getting calls that, with solar happening and a lot of other things, people are getting dislocated from their leases. And then now you're talking about $125, and if you're at 5 acre feet, and that's $625 an acre, and no one can afford that kind of rent. It's just an issue that's going to keep compounding. And then it brings up one last thing, and Tina was kind enough to speak to Kiwanis in El Centro, and I think the community is really not aware of the issue where the QSA is leading us to, and it's kind of pushing us faster and faster as we keep increasing the scale. It has to do with where do we end up when we dry up the Salton Sea? What happens with the mitigation if that doesn't come to fruition with the state? We're pushing ahead as if it's all taken care of, but my understanding is we still are working on the mitigation. I'd like to see more of that being talked about. Also, there was a joint chambers tour that people from San Diego and around the county went up to the Salton Sea and looked at what mitigation was going on. Farm Bureau has never been invited to do that. I used to sit on the board of Farm Bureau. I had to get off as a result of running for office. It would be nice if some of the public would be able to see some of these things that are going on. So we feel a little sense of relief that actually things are moving forward. I, for one, living in Brawley and farming in Westmoreland and around the Salton Sea, I just see it going down. I think it's gone down 3 inches in the last year. That's quite a bit when you look at how much it moves out in 1 year, and it's only 3 inches, and we're talking about feet being cut off the Salton Sea. So I think long term we just have to really keep in mind it's not just about fallowing today, it's about the long term of the valley and what we're doing. Thanks.
Any other comments? Any other board comments? Tina, do you have any remarks?
I
on
can respond
Mr.
to a
Benson?
couple of Steve's questions.
Yes.
The fallowing volumes are dictated by the contractual requirements and the mitigation obligations, so we don't have flexibility as to the volumes in the first 15 years, and that's just the nature of the beast we have to deal with. So it's not a matter of saying, can we do it on farm instead of fallowing? Contractually, we can't even initiate on farm until next year. The only flexibility we really have is in payback mechanisms. So to the extent we overran in 2011, we can look at different alternatives to generate that water for payback in 2013. I would certainly advocate on farm, just knowing it's going to cost more to generate that water. But I would certainly say to the extent there's on-farm opportunities available and to the extent the budget can afford it, we should definitely try to aim to do as much overrun payback that way and just backstop with the fallowing to minimize it. So that would be the goal.
Yeah,
And we can do tours. Steve, I don't know where you went. Most of the tours that Bruce Wilcox has provided, we've been requested to do. So if anybody's interested in seeing mitigation activities, just give us a phone call, and I'll ask Bruce to prepare an update on the mitigation activities for the board.
Tina, you may want to mention another reason I think we're having some trouble getting the fallowing is because we stopped fallowing because we didn't know how the court hearing was going to turn out. So that put a big hole that we're trying to fill.
Last year, under normal circumstances, we would have gotten half of this year's obligation, which would have been about 50,000 acre feet of water in the last fallowing program. We didn't do that, so we're playing catch up at this point. We're actually very close to meeting this calendar year's obligations. We're just trying to catch up from last time.
Yeah, I just want to make a couple of comments before we vote. This issue's always been very controversial, and I realize that it's competing with rents Even when it was back at $85, it was competing with rents and creating a lot of problems out in the farm community. But as Tina said, we have a contractual agreement that we have to fulfill with San Diego County Water Authority, and we have to continue to move forward. So is there any other board comments?
Yeah.
Okay, please vote. Okay, thank you. We'll move on to item number 8, which is the approval of the plan for the IID to transition to an in-house 24-hour trading operation. Mr.
Good
DeVoy.
afternoon. Dan DeVoy, Manager of Human Resources and Loss Control. Last week, we presented to your board a business plan transitioning the merchant trading operations to a 24-hour operation. That plan included the augmentation of the staffing and adding 2 new trading analyst positions. That creates a new alternative pathway to the trading floor for employees. That plan also included transitional marketing services, an RFP that's been released to cover the shifts while we're in this transition, and also to cover security and additional hardware, lighting, and lighting and cameras and things like that because of the 24 nature of the operation. With the feedback we received from your board and from the GM after last week's at last week's meeting, we've modified the plan to include the restructure of the operations so that now we're recommending that the trading operations would report through the resource planning operations to the energy manager. And that would effectively create an ethical wall that would be consistent with the spirit of FERC 888 and 889. So that's what we've changed since we met and presented this to you last week. So we're asking that you approve that transition plan with the inclusion of that new structuring of rerouting the oversight of the trading operations.
Okay, is there a motion, and then we can have discussion?
Going to have the...
Does Greg want to talk?
Mr. Merrigan, isn't going to come and make a
Greg.
presentation?
There
He's
you
not going
are.
to get off that easy.
I was going to get a motion, and then you could talk. Go ahead.
Yes.
Introduce yourself for the record.
Greg Merrigan, consultant to the Imperial Irrigation District. We heard what you said last week, and we came forward with a plan to split out the trading function from the SOC to the planning manager, the trading function would then report up through to the energy manager. That way you have the SOC, the reliability function, and the merchant trading function separate, in the spirit, like Mr. DeVoy said, spirit of the FERC 888, 889 rules.
Mr. Kelly, do you have a chance to review the reorganization?
I have, and this is largely the work product of Mr. Merrigan in consultation with Mr. DeVoy, and I think represents the consensus of all the affected.
Do you think or do you agree?
I do.
That's my question.
I do agree, and I would recommend that the board move forward with it.
Thank you.
When is the final date for Coral? June 12th. Have you had a chance to review the Coral contract?
Yes, I have.
Have they met the obligations of that contract?
There's certain provisions in that contract where not only do they have to cover shift vacancies, nights, weekends, and holidays, but they are required to provide certain models, forecast on a monthly and weekly basis.
Can I have a motion on this?
I move to approve the attached business plan transition, and then also to include the reorganization of the merchant supply and trading section.
All right, that's a motion by Director Mendoza and a second by Director Sanchez, is that correct?
Yep.
Okay, is there further discussion on this?
Yeah, I have some discussion.
Go ahead.
Greg, we have a flow chart today that's presented to us, and we have the number of positions that are presented to us. How many positions in total are we talking about, both currently budgeted, unbudgeted, when we're all hired out and up to speed? How many positions is that?
You're talking 6 positions, 4 are budgeted, 2 are unbudgeted, which are the new analyst positions.
Uh-huh. So overall, it's going to be a staff of 8 people.
11 counting supervisors and the analyst, the current analyst.
11, including the supervisor and the analyst. And that'll enable us to be 24-hour and flex our staff and meet all the standards.
Yes,
as
that
far
is correct.
as manpower goes.
Mhm.
I've got 2 comments here, and I've made them before. The one is we're going to have an interim consultant contractor taking care of our real-time trading while we're developing this staff.
Yes, to take the position of Coral and shift vacancies.
To take the place of Coral. Is Coral could also bid on it during that 6 months, is that correct?
That is correct.
Okay. My point is a lot of money and resources have been put towards this at the IID over the years. And now when we're getting this close to taking it on and doing it, I don't see that intent and interest in training. We're looking at Blue Water training expenses of, I believe, $35,000.
40, I believe, yes.
$40,000, and then the rest of the training will be done by existing staff that we have.
That is correct.
But that staff that we have right now, we're only trading 8 hours a day. We're not doing 24-hour trading. So we're not having 3 8-hour shifts where somebody's handing the baton off at the end of the shift to the next shift, documenting it, reporting it, entering it into the computer database, whatever they have to do. We're not familiar and experienced with doing that. Is that correct?
The majority of the staff that's on currently right now are experienced in taking over the shift from Coral. There's a handoff from the night shift to the day shift. There's also majority of the staff comes for the SOC currently, and so they're very experienced in that type of shift change operations.
Yeah. That's good. I didn't realize that there is a handoff between
Yes.
Coral and us. Thank you for that correction. But what I'm really interested in here is additional training experience and expertise. If we're going to have someone supplying this contractor consultant function during 6 months, I think it'd be advantageous to the IID to allow our trading, these 11 positions, including management and sub-management, to spend some time at that agency and to see how they run their operations, to see how they hand off the baton, to see how they document their records and keep track of things. And then the second thing is the complexities of the SOC and setting up the traders, and the fact that some of these positions appear to be coming from the SOC, and keeping the integrity of the SOC together. As we've been mentioned before, we're calling it, I guess, cannibalization of the SOC. We don't want to see that. So that is still an existing concern of mine.
Okay.
I would just like to thank Mr. Kelly. We brought this up first time in 2007. I think we saw it was about a delta of about 10 million, and it's finally happening 5 years later, but it's happening. The 9 million that could be saved because of the non-optimal transactions will more than offset this cost. It brings it in-house, and I can sleep good at night.
Actually, I'd like to extend some kudos to Mr. Merrigan, who worked with Mr. DeVoy to fashion a plan that we could present to you, mainly to approve 2 unfunded positions, because we have the other positions in the budget. But the $9 million has been verified independently by Mr. Merrigan, and we will take as much time in the interim as is necessary to launch it correctly when we do so.
I think it'd probably be fair to say these are the people that no one ever gets to see. They're secured, locked away, keep the system going. A tremendous amount of stress in this job, keeping it going. It's the backbone of keeping our balancing authority together. And I'm like Director Desert. I just want to make sure that we get good training for these people, because it is one heck of a responsibility.
Yeah, will there be a benchmark set internally in your discussions with staff about training and meeting certain requirements before these people move on, since they
Yes,
are going
most
to be
definitely.
on a probationary status?
They've had the luxury so far to have experienced people come in. So for like the new trading analyst, when they move up to get them qualified, they got to be NERC certified. There's going to be a job description, check marks on it. They have to get a sign off of 2 of the existing shift traders and the supervisor before they're allowed to go on shift.
So they're going to be NERC and FERC certified.
You bet.
And is there going to be any kind of talk of redundancy or moving people back and forth from the SOC to the traders, not during the same time, but overlapping and training?
Yes, cross training is definitely a part of the plan.
Both not just at the traders, but at the SOC.
You know, we had not discussed that. It was more about getting the merchant trading.
Yeah,
function
getting the
up to
traders
speed.
up and running, but then later on, we've got to keep that SOC solid and strong, and some of these people are going to have some of those same qualities and characteristics to perform that function.
It does. It has come up in the course of getting this in shape to present to your board, that SOC has been a proving ground for this real-time function. And as we go forward with it, it isn't just the cannibalization, I think, that we have to guard against. I think we have to look at DOC, SOC, and then this new function as a sort of continuum that has to be somewhat interchangeable.
Mr. Merrigan, I just want to thank you for working with Mr. Kelly and Mr. DuBois to bring this about. And so thank you very much for that.
You're welcome.
And you're definitely recommending this for board approval?
Yes.
Okay, good. Any other comments?
No, I also want to thank you for your
You're welcome.
input. You and I had a lengthy discussion, and I asked you some really tough questions, so I'm satisfied with what you brought forward.
All right. Thank you.
Okay, please vote. Okay, thank you. We'll move on to item number 9, which is approval of biomass contract with Desert View Power, Inc. And Blend Valenzuela is going to handle that.
Good afternoon, Board of Directors. My name is Belen Valenzuela, and I'm an interim assistant manager for resource planning. And basically, I'm coming forward today with a biomass contract. At the March 6th board meeting, I had come to the board with a renewable portfolio standards policy, a draft form, which kind of laid out a detailed enforcement procedure and renewable plan. And within that, it was identifying the district's plan in order to meet the Senate Bill 21X requirements of the RPS standards, which is during the compliance period 1, which ends December 31st, 2013. 20% of the resources need to come from a renewable resource. And in compliance period 2, 25%, and then 33% for 2020. So part of that plan, there was a geothermal biomass project in there that was going to help the district get there, and this is the biomass portion of that resource plan. So basically, over the last couple months, staff has been working with a biomass facility, the Desert View Power Incorporated, which is within its balancing authority, on a 10-year contract, which is basically it's a 10-year contract with an option to extend. So it's for 45 megawatts, and it would cost on average about $35 million annually to the district. It is currently connected to our system and has IED's meter, and it's ready to go. The plan is to get it. Actually, the plan is for us to actually start taking the energy May 1st of this year, which, like I said, will help us reach the standards for compliance period 1. Anyway, I kind of jumped ahead. So this is what you were presented on March 6th. This was the Energy Resource Plan, a summary of it. So right now, with our current hydro and the executed solar contracts, the district's at about 12% of the 20% for the compliance period. So where this contract would added additional 6% to that, which would bring the district to 18% of the 20 for the first compliance period. About the plant, it basically is a state-of-the-art biomass plant. It's one of the biggest in California. It burns the wood waste, the forest residue, and agriculture residue. It's operating at about a 93% capacity factor since about 1992 or after 1992. So anyway, it's gotten a lot of awards it's gotten one big award for the, I'm sorry, I have these glasses and they're not farsighted. I'm trying to adjust them. I'm sorry about this. Anyway, it was named as one of the Power Magazine's top 6 renewable companies in December of 2010. So it has been in operation since 1992. And like I said, I have on there, it performs greater than 90%. It's been at about a 93% capacity factor since 1992. I also wanted to mention to the board that it has gone to the Energy Risk Management Group in March, and it got unanimously approved on March 28th from the Energy Risk Management Group, which is chaired by our CFO, to go for board approval.
Mrs. Valenzuela, is 100% of that biomass referred as green energy, or is there a percentage?
100% of it is green.
Considered green energy?
Green energy, yes. Okay. And what's a little bit different, and the president of Greenleaf is here, so if there's any real specific questions, I'm sure he could answer. But what's really different is it's gotten all kinds of awards for its efficiencies compared to other biomass facilities. And it's, like I said, it's the largest here in California. So this is a picture of it. You've seen it like on your way to the La Quinta office. It's right off of 10 on the right-hand side.
Do you need him to say a few words?
I would just like to introduce him, if I could. Hugh Smith, he's the president of Greenleaf.
Good afternoon, Board. I've met most of you individually, and it's good to be here today. And
you haven't met me, though. I haven't met with you.
I haven't met with you, but I introduced myself before the meeting.
All right, just for the record.
Yes, it's good to be here. We've submitted a competitive solicitation for the plant to IID to consider. And after consideration and lots of negotiations, we've reached an agreement on a set of terms and conditions that we think is a very good deal for IED moving forward. Obviously, I'd say that Greenleaf is an operator of biomass plants throughout California. We have over 100 megawatts of plants in the state, and are bringing a consolidated, synergistic look to operating biomass facilities. We have ambitions to expand well beyond the state of California and grow into other markets as well, and bring the efficiencies of that type of expansion to all of our facilities. I saw a couple of articles this past week about where are the green jobs, and we like to talk about that in particular in the biomass segment of the renewable industry, based on the fact that of all the different technologies between solar, wind, geothermal, and biomass, the 4 major technologies that consist of the makeup of most of the biomass energy in this country, by far and away the biomass sector provides the most jobs for our local communities. And we have 39 employees at the facility, and we have full-time employees of 130 employees that support the facility on a full-time basis, all local jobs. And in addition to that, the cost and the expenses for running this facility all stay within about a 75-mile radius of the plant as well. And
do your employees also receive benefits? Is it?
They do.
They do?
They do. They receive 401k plans, medical benefits. It's about 75% Hispanic population of our employee base.
Why do you tell me that?
I'm just letting you know that we have a strong minority presence in our workforce. The average employment of the employees is 11 years. And so we typically have employees for the long term, and they come to work for us and they enjoy working there. because it is a really high-paying job for the area in terms
What
of
is
the
your
type.
average wage per hour? Do you pay salaries?
No.
Do you pay per hour?
No, they're hourly
So they
workers.
vary from where to what?
I would think the lowest paid workers are in the range of about $16 an hour, and the higher paid positions are in the $28 to $30 per hour range. And then we have managers on top of that that have the salaried positions that are paid slightly more than that. And so with that, I think Belen mentioned the fact that this is a facility that's ready to go. It's going to have the ability of providing Bucket 1 RECs to IID in the near term and allow them to meet help them meet their upcoming Compliance 1 period standards and requirements for the renewable portfolio laws that are in California. And we just think it's a great fit for both organizations, and we're looking forward to the partnership moving forward. I think everyone on the board knows that this facility has been a customer of IID for the last 20 years, and it's been a wheeling customer providing, with IID, providing transmission services to the plant. And so we have been a customer of IID's for many years, and this is going to be an expansion of that partnership and providing energy as well.
All right, Mr. Smith, thank you very much for coming to the podium. Any further discussion? Okay, we have a motion and a second, right?
No, do we
No.
have? No, we don't.
Okay, would somebody want to
I
entertain?
move to approve the biomass contract with Desert View Power Incorporated.
Is there a second? I'll second it. Any discussion by the board?
Just like to say that, whenever the idea is looking at procurement for the different renewables, we always have our ratepayers in mind. This fits into that risk range, and I think in the long term, when all the renewable requirements are said and done, I expect to see IID with the lowest rate still.
Okay, any other comments? Okay, please vote. Okay, thank you. Thank you, Belen.
Okay,
Thank you, Mr.
Thank you
Smith.
very much, Board of Directors.
And I appreciate all the work you put into this, Belen.
Thank you.
A lot of work.
We're going to move on to number 10, review approval of major work authorization, Coachella Valley Substation, Bank Number 4 addition. Mr. McCann.
President, board members, Dan McCann, Assistant Manager, System and Trading Operations, that I guess is actually System Operations now. I'm going to present and request approval of a MWA to move an unused existing transformer from Dixieland to Coachella Valley. This is 2 phases. We're proposing to do it in 2 phases. Phase 1 is doing what we need to do to try to get this transformer moved this summer, before the start of this summer. And that entails actually moving the transformer from Dixieland to Coachella Valley, installing it at Coachella Valley, taking the 2 existing transformers that are there now and tying them together, which in effect will give us 2 300 MVA transformers at Coachella Valley. And this is an effort to prevent loading problems on the Coachella Valley transformers this summer. It's difficult for us to control the loading on these transformers with our resources and the impacts that other systems have on power flowing through our system. We are requesting that most of the major work be sole sourced, and that's due to the time constraints. We're hoping to be able to get this installed by the first part of June, like I say, so we'll have it for the summer. The phase 2 of this project will come back to the board for approval for that. The buses there at Coachella Valley need to be upgraded. We don't have to do that before summer. There's a couple circuit breakers that need to be replaced that we can put off till after summer. So we'll come back with the phase 2 of this project after summer if this is approved.
Okay.
To approve.
Second, but I have a question, Mr. McCann.
Sure.
By removing the transformer from Dixieland substation, how is that going to impact Dixieland.
It's not in service at Dixieland.
It's
It was installed there for a future project that hasn't went forward yet, so it's not in service at this time.
And it's still in good work, it's still in good working conditions, and you have it checked out so that it will meet our needs in the Coachella Valley?
Yes, we had it tested before we started this to make sure that there were no known problems with that transformer.
Is it still under guarantee?
I don't know.
Would you find out?
I will.
Thank you.
Okay.
Okay, we have a motion on the floor by Director Hanks and a second by Mrs. Mendoza. Mr. Director Desert, do you have comments?
We're going to move the one transformer by June, and we're going to put the other two that are existing up there in parallel or in series.
That's correct.
And so the impedance, the capacity, the frequency, everything is copacetic, and that those three transformers will work in unison to increase our capacity and assist making our system more robust.
That's correct. They're very close impedances, so we do not see any problems with them operating in parallel.
So they don't have to be exactly the same impedance. They can be within a certain.
Yes.
And then the phase two. The phase one is $1,900,000, $914. What's phase two? What's the ballpark of phase two that we're looking at?
I don't have a cost on that. The buses really need to be upgraded even now, so that's a cost that we would incur regardless. But we're getting those figures together so we can come back with a cost for phase two.
So in phase two, it's going to be okay and fine for our system to have that done phase two after the peak summer load is over.
Yes, the only adverse impact that we could have is with certain equipment out of service there at Coachella Valley, meaning one of the buses or certain circuit breakers. Then we would have to derate how much we could bring across those transformers.
And then the additional system that runs south from there, the one that kind of cascaded, was the terminology in the blackout. Have we took a second look at those relays and those settings and taken steps so that activity wouldn't happen again if we had a similar type of event?
Yes, we've completed reviewing that. We have the settings designed. And we're going to install some additional relays to allow us to set the exact settings that we need for those transformers.
And what date will those things be set up and installed?
They should be done within the next month.
Yeah, thank you.
Any further questions for Mr. McCann from the board? Any questions from the audience? Please vote. Okay, thank you. Thank you, Dan.
Thank you.
We're going to move on to finance, and that's the informational item number 11 is strictly information discussion on proposed economic development rate, wheeling rate. Mr. Ivy.
Greetings, board members, President Menville, Joel Ivy, Interim Energy Manager. There is no changes to the slideshow. I'm kind of loath to run through this again. I think we've all seen it at the workshop. Unless you guys want to just thumb through, I'd like to just kind of hit the high points of comments that we've received and kind of focus on that aspect of it. We did sit down and meet with SolarGen. They had some comments that they wanted to talk about. Their concern was in regards to if we were going to have a requirement that they needed to meet a certain megawatt value 1 hour through on a 2-year average, they were concerned about how that would impact their point-to-point arrangement. We had that discussion, and the interest that we have is making sure that we can take care of or take advantage of any capacity that we have in excess of what we have reserved or that's not being used to export out of our system. I think we got that issue cleared up with SolarGen. Have not heard back from them that there were any further issues. We had a really good conversation with Cal Energy, and they had a few comments that they wanted to run through us, and they had a couple of suggestions. One of their suggestions was that we would consider capping the amount of funds that we would use for this program or for this new rate. And our thought on that was that's something that we can apply at a later date, and it's not something that we really need to take to consideration right at this minute or this time around. They requested that we examine the notion, and this exists within the open access transmission tariff processes now, where a newcomer to the system can, if somebody's taking service at a lower price, a newcomer to the system can can more or less force a bid process so that the person that's existing would have to up the rate that they're paying for that in order to make sure that the costs are being recovered fully. We didn't really feel like that was in the spirit of the economic development rate to offer this on a long-term firm basis. It is something that we said that we could discuss further with Cal Energy, but we didn't want to incorporate it as part of this process. And one of the last issues that they brought up was the whole notion of the free rider. So if they come along and they help pay for costs and incur the cost to upgrade the system, and then somebody comes along a little bit later and gets to take advantage of any excess capacity that might have been built into that. That's something that we have reviewed. We're going to continue to review. Again, we don't believe it needs to be made as part of an OAT change in the process that we have right now today. There are some FERC processes that are in play as we speak that are starting to address this kind of an issue, but right now it's not a widely known cure to the problem that they were looking to get the benefit of. And then I guess finally I did see a copy of a letter that they've written with a suggestion for a change. Just given a cursory glance, I don't really see a problem with the change that they're suggesting. I would like the opportunity to visit with the financial folks, with the OAT contracts person and Debbie Swanstrom, just to make sure it's just one word. And I think all they're trying to say with that is that we don't, or that we allow whatever revenue requirements are in play at the time to be the consideration for how we're using the Energy Balancing Authority Fund. So that doesn't seem to be a big deal to me.
Any questions for Mr. Ivy?
I'd just like to make a couple of comments. When we started working on this economic development rate, we realized that the generators connecting to IID were at a disadvantage as far as getting PPAs. With the economic development rate, we've improved a lot for the solar people. There's not that many projects hooking into our system, but we really haven't provided a benefit to the geothermal people on this process. I think somewhere down the line we're going to have to take a look at it, especially if they're not competitive. I think we're probably all in agreement that the next wave of renewables will probably be geothermals and the need for base load. So hopefully that helps out. But I could understand why the geothermal would be concerned because it does improve their competitors' position, and it doesn't really help them. And quite frankly, in the long run, probably geothermal, well, we know geothermal provides more jobs and tax base and so forth. So I would just ask that, we, at somewhere down the line, we revisit this with geothermal and see where we're at.
To the board, I would just encourage the board to be mindful that when we first embarked on or talked about an economic development-based intermittent rate, it was to level the playing field for solar generators. I don't know that the baseload, specifically geothermal industry, is in exactly the same sort of predicament. But I do think that now is the time to be thinking about incentive because I do believe, and I think the board has seen, that next wave is probably a year to 2 years away. So the planning for it ought to occur now.
And it gives us a window and opportunity to start working with them also.
Yeah, based on our track record, yes.
Any further comments from the board? Any comments from the public on this issue? Mr. Ivy, you have anything else?
I don't. I'll just say we received a lot of very good, thoughtful feedback from different participants, and it's very much appreciated the way that we work together getting through this process.
Okay, this will come back for action when?
Next week.
Okay, very good. All right, item number 12, thank you, Mr. Ivy. Item number 12, approval of a service agreement with Moss Adams. Ed?
Good afternoon, President Menville, members of the board, Ed Hall, Deputy Manager, Financial Services. If you recall, last week I brought a service agreement request for Moss Adams to extend services relating to ad hoc consulting and tax advice and general accounting advice. The service agreement is an amount not to exceed $50,000 and extends through the year 2013. And if you have any questions.
When was the last time we did an RFP on these services?
These services are done at the same time we go out for the audit RFP. So when we go out for the audit, which will be in 2013, we'll
So you'll do
include
another
these as
RFP?
part of that RFP
Okay.
process.
Okay. I move to approve the service agreement with Moss Adams.
Or a second? Okay, it's been moved and second. Any discussion? Please vote.
Wait.
What?
I mentioned last time about whether there was a conflict with them auditing services that they perform.
Right, I did look into that. The governmental auditing standards, which is put out by the U.S. Government Accountability Office, they call this the Yellow Book. It has a section 3.4 and 3.41 that talks about it. And the 3.41 actually lays out the services, very specifically the services that are being provided under this agreement. And it specifically allows the provision of advice on accounting matters. It mentions such as they're allowed to do research and advice covering technical questions on tax matters, tax laws, and so forth. They're also allowed to provide advice on routine business matters and best practices and benchmarking studies. So those are the services that have been specifically allowed for under the governmental auditing standards.
Okay.
And that's what we're going to stick to in this agreement.
They're not doing any of the work themselves, the calculations.
No, it's strictly advice. It's interpretation of literature and legal and accounting literature, and then giving us their opinion. Now it's up to us to either take their advice or not, but they're not doing any of the work themselves.
Okay, any further questions from the board, staff, public? Please vote. Thank you. Move on to item number 13, adoption of resolution declaring various transformers as surplus to the district's needs. Donna?
Purchasing agent and now in the finance department. So we are asking to get approval to declare these transformers as salvage so that we can go through the disposal process.
Approve the resolution.
Is there a second? Okay, it's been moved and second. Any discussion by the board?
Donna, are any of these transformers repairable by our staff?
No, because the energy department has their own methodology for declaring which transformers can be repaired and which ones have to go to salvage. So,
Well, do we still repair some?
we do some repairs, yes.
Okay. Rebuilding?
Rebuild ourselves. If they had something that they felt was rebuildable, they would send it to an authorized repair facility.
Okay, any further questions?
Yeah, Donna, we went through this same type of a situation getting rid of some transformers a few months ago, I believe.
Mhm.
And I think they were significantly smaller in size last time. So my question is similar to Director Hanks, or maybe somebody from the energy department could tell us, these larger kV transformers, they're not repairable or hold value to the department that we should be looking at?
I apologize. I would have to assume so, because we wouldn't want to. Otherwise, we would be selling those at more of a full value, or looking at some kind of arrangement with our suppliers to help trade that out. So I do apologize, but I would have to assume that they're not repairable.
And is this normal, Donna, that we get rid of the transformers in this kind of frequency at the ID, or has it built up and we're doing a replacement
No, we periodically have transformers that are replaced in the system. It's just that with the passing of the policy last May, we were charged with bringing all the surplus to the board, and so I think that's been something that's kind of like a regular, I don't want to call it a waste stream, but it goes on and on. So you will see these periodically.
Thank you, Don.
Mm-hmm.
Any further questions? Okay, please vote. Thank you. Move on to item 14, adoption of the resolution authorizing the approval of documents related to the issuance of commercial paper program Series C notes.
Good afternoon, President Menville and Board of Directors. Teresa Perez, Business Control Analyst in the Finance Department. Last week, CFO Greg Broking brought to you an information item on this, the CP program. We're looking to add an additional Series C notes, which is a maximum capacity of $200 million that would be able to be used for both energy or water. It does not increase the program. It just adds a little bit more flexibility and increases energy's portion by $25 million and water's up to $200 million. Seeking approval.
I move to approve.
Is there a second? I'll second it. Is there any discussion?
Yeah, I have some items I'd like to discuss. On these series and these limits, are they limited to each series, or is this to the total series?
The limit is $200 million on the entire program. If you have Series A outstanding, which can be issued up to $175 million for energy or $75 for water, if you have any additional series outstanding, it is limited by whatever is available in the program. The other limitation is also if you have letters of credits up to that maximum amount. Currently, we only have $100 million, which is limited to $75 million for energy, $50 million for water.
Is the intent to, at some point in time, to roll the commercial paper into an obligation bond?
As Greg indicated last week, right now for the Energy Department, we currently are looking between 25 and 50 million being used for energy. The plan currently is not to roll it into a long-term bond, but in the future, if we utilize it, it may roll into future, but current plans don't have it.
Well, what is there that was in the budget that we just approved? I mean, we're in the first quarter that we don't have funding for.
If you recall, actually, the CP program, there was some funding on Energy's capital program of about $25 million. I think it was designated for transmission projects. And so that is how we had it. We did have in the budget to roll it into a long-term financing, but we've worked through forecasts for the Energy Department, and we have removed that and actually have that not rolling to a long-term. And water does have, I believe it was about $9 million.
I think it's actually distribution projects.
Excuse me.
Yeah. On the commercial paper, it was always my understanding that they were basically short-term loans for 2 to 270 days.
Mm-hmm.
What's the longest amount that we have currently on these?
We just issued $25 million of commercial paper for the Energy Department. I believe it goes out to July 12th. So it's less than 270 days, but the maximum is 270 days. And then you can roll it for an additional period of time.
Well, I looked through the budget. I couldn't see where the CP was shown in there as revenue in this budget. So
it would be in your capital budget if you look at Energies and Water summary page in the E sections. I don't have the budget book in front of me, but if you look at the E section of the budget book, the summary pages, you will see it as a funding source.
It became a funding source before we approved it.
No, well, the CP program is actually in place. This would be, well, we were actually anticipating to utilize Series A notes, which is currently approved and in place.
And Series A notes go up to $100 million?
They go up to $100 million. That's our letter of credit right now with Union Bank. And Union Bank, their reimbursement agreement only allows us to issue Series A notes, which are tax-exempt notes for capital programs, capital projects.
And for capital projects, you mentioned earlier some 25 million for designated for energy. Why do we need to go above 100 million? Is there something else out there that's coming that we're going to be doing on the water or the energy side that's going to take us above the $100 million cap that's been functioning for us?
We actually right now don't have plans to utilize the full 200 million. We would like to have additional liquidity in the event we needed it. I know for the water side, we're looking forward to the water transfer and the QSA system conservation. This would be a short term to roll into a longer term bond, and that's what we would be looking to utilize. Now, waters is limited to, I believe it's 75 million right now with the current program.
So on the water conservation, we're talking utilizing this money for a bridge money for the
bridge money,
water
yes.
conservation for the definite plan.
But yes.
So that's up to the $200 to $300 million plan.
Yes.
I think 100 million is enough that keep us in context and functioning the way we have been.
You know, I'm very concerned about our long-term debt, and we just keep heading that way. At some point in time, we have to have some space for any type of emergency or crisis that comes along to meet that. And if we just keep encroaching into this and taking on obligation debt, bonds, but yet there's no commitment, no request how we're going to pay this back. You know, it's going to impact our rates. We're already getting into trouble with our base rates, and that may be why we're borrowing. Are we off balance with our base rates?
I would have to defer to Greg, but I think our current rates are sufficient to cover our existing obligations for both water and energy.
I did see a presentation a couple of weeks ago Mr. Broking put on at the Energy Department. He is planning on making a similar presentation to the board next Tuesday. And it's my understanding that the $200 million is already on the books. He's simply looking for a second carrier for the extra $100 million. Is that right?
Actually, the program, the $200 million program, is already in place. It was approved back in 2007. Citi Bank was the first one to issue us a letter of credit. They actually had it to the maximum capacity of $200 million. This is just adding an additional series of notes that would give us the flexibility to utilize that program for either one. Currently, there's only $25 million outstanding. There is none outstanding for energy. There is none outstanding for water.
But it is true that there's $35 million in distribution projects, identified distribution projects this budget year that he intends to use or would like to use $25 million in commercial paper to pay for.
Did the resolution create a problem?
I'm sorry?
Did the resolution that we passed with the budget create a problem?
You know what? I think what we did is we incorporated the decisions from, or the direction from the resolution into our forecast. And that's what we'll be bringing to you next week. Whether it created a problem or not, I'm not sure.
Yeah, Mr. Kelly, I get the feeling that some people think that there's something sneaky going on here, that we're trying to get some money through for the water system improvements. So I think it's best that we wait until Mr. Broking comes back and we discuss this so he can answer these questions, even though Teresa's doing a good job.
Yeah,
but I don't want to think, I see Mr. Benson lined up and Mr. Kuhn lined up to talk. I get the feeling that there's something going on here with the water system improvement for the transfers. So let's get Greg down here and discuss this.
That would be fine. He intends to make the presentation to the board that would include these distribution projects next week anyway.
So I'll pull my second. Would you?
Well, yeah, but Ms. Bettis, is time of the essence? Can we wait another week? Does it matter?
You know, this actually has to go through a validation process with the legislature, and if you're making any changes to your commercial paper program, it has a minimum of 6 months that it goes through once the legislature validates the program. And they've got a 6-month waiting period before you could actually start utilizing the program. And so...
So no, it's not time bound.
Well, you know, the 200 million to me is just like a credit card, you know, and, you know, everybody knows that we cut up credit cards.
Now we only have $100 million in a letter of credit. So right now our maximum is only $100 million because it's all bound.
What is it? What I'm getting at? What is it that this money is intended for that we're not being told?
It's the distribution project's $35 million, and you need to see that.
And it was designated in the budget for CP money?
I don't know that.
Would you pull? You want to pull a?
Yeah, I'll pull my motion, and then we can
let's just
bring this
this.
back next
Mr.
week.
Sanchez, you had a comment.
Is that fair?
If you do want to look at the budget book, it's on page E3. Line number 12, I believe it is.
Is that your recollection, Mr. Ivy, of that meeting that I attended?
That is correct. We had $35 million in distribution projects that we're looking to try to get funded. Mr. Escalera has been looking at some cutbacks of that he could get away with making if he can, and working with the financial group to make sure we're arriving at the right number. But that money is intended to be used for distribution.
Before making decisions like this, I like to be reminded of our debt-to-income ratio, our credit score, so to speak. I know that we were at AA or...
We're at AA minus by S&P, A by Moody's, and Fitch on the energy side.
And debt-to-income ratio, I remember there was an article a year and a half ago, 2 years ago, we were about between 30 and 40%.
Yeah, I think with the refunding or the financing of Unit 3, I think we're about 52%.
52%. And if you can ask Mr. Broken to come back with reports of organizations lower than 50, at 50, higher than 50, and will this commercial paper take us to 55, 52? I mean, I understand organizations start to get into trouble. Anything, I believe. I mean, I try to keep my household under 50, about 30% debt to income ratio, just with the house payment. So.
Okay, so you would like to see entities that have lower than 50?
Yeah,
you
can get that to me on the side, and just I can take a look. Thank you.
Okay. For a public utility, though, like either water or power, it is pretty common to have higher debt to equity ratios because they're so capital intensive.
Well, with my understanding with CP paper, it's usually at a very low rate, and it's one agency loaning money to another one, and probably both of them probably have pretty high ratings. Just one has a little capital or cash to invest. But if you borrow it at that rate and then you roll it over to a bond, we don't know what the interest rate's going to be on the bond. You know, right now they're pretty favorable, but it could jump up there 6-7%.
Yeah, and as Greg stated
trouble in a hurry.
Yeah, as Greg stated in last week's meeting, he didn't feel comfortable rolling anything or even issuing anything greater than $50 million for energy because he didn't feel that there's sufficient room to roll that into a longer-term bond.
Okay, this item will be brought back when Mr. Broken's in town.
That 270-day you say is the length of the
Maximum that you can actually issue the paper. It can be shorter. It can't be any greater than 270 days.
That means you have to pay it all back by 270?
You either pay it back or you have the ability to roll it again to another.
And have we been paying it back?
We refunded on the energy side last year. We did 3 refundings and
3 refundings.
3 refundings for Unit 3.
3 refundings.
Mm-hmm.
Okay, Mr. Benson, did you have a comment?
I just had a question. I'm a little confused that you mentioned 2 banks. One bank's already in existence, Citibank, and then this would be a second bank creating the same commercial paper loan essentially to IID?
No, The Citibank letter of credit actually expired August of 2010. Union Bank replaced that. It was only at $100 million. Citi's was at 200. That did expire in 2010, and this is the replacement of the letter of credit. And it's only up to $100 million.
So why wouldn't you just go to a letter of credit where you could specify the use at a later date rather than going to commercial paper where you're actually borrowing the money? Because if you're issuing commercial paper, you're physically borrowing the money and you don't have a use for it yet, correct?
No, the intent of drawing on the letter on the CP program is to fund capital projects, and so that is the use for that.
Okay. The only thing I would request from the public is that if there's a list of what projects it goes to fund and then the cash flow anticipated in the budget, I assume that there's a cash flow statement in the budget that kind of shows what you go through during a given year, but it's just the same way I operate my business. You know, you have to look out in the long term and know you're not going to run out of money. It's been brought up on the system improvements that there might not be enough money. There was $50 million that San Diego paid the IID or loaned to the IID. My understanding was that was what was going to kickstart the system improvements. And then we're also getting additional money with additional fallowing that's going on. We did transfer water last year without having to pay farmers. So my understanding was there was additional money already set aside in the water transfer program. So I'm a little surprised that you need to go and borrow another $200 million when you already have money sitting in the bank.
Mr. Perez, that Mr. Benson brings up an interesting point where are we going to pay? We have a history of borrowing and paying it back with the 3 refundings. Do we have a plan laid out as far as when we do borrow it that we will pay within 276, and will Greg bring that back to continue with the history?
That is the intent, and that's what actually when we tried on Unit 3. Each one of those series was a refunding of the CP program. I think Greg had laid out that was our intention to finance that project because we weren't able to issue the BABs in 2010, and so this was the route that we went. Because of litigation, it was the CP program was validated, and it was going to be more difficult to challenge legally when you went to refund a commercial paper program that was already validated.
And the reason is it the CP program, does it work the same as the home equity line, where every time you make a payment, you pay less on interest on that money that's left over, and not like a bond where you pay about 80% more because you have a 30-year bond, where usually an equity line is if you have a 5%, and right now equity lines are cheaper than fixed. If you have a 5 or 4% on your equity line and you owe $1,000 and you pay a $100 payment, now you owe $900, but your interest on that money has become lower, where on a 30-year it's usually, there's a set amount. That makes sense to you? You know what I'm saying?
I think what you're trying to say is, and let me see if I understand it, is if we issue commercial paper program, we issue $25 million, it's set at a rate of, I think, 0.22%. That rate will stay on the money as long as it's outstanding. If once it's rolled and the maturity comes, if we reissue it, it would be based on a different rate.
Okay, so you can't be paying into that. You can't. It's got to either be all of it in 276. Or you can't pay like a quick $5 million next week, so to speak, because you may, there's some extra cash flow, and then you only pay that 0.22 on what's left.
And look and see, but typically that's not how the program works.
It's that you'll recall the All American Canal lining where we a shorter term instrument.
Okay, so that'll come back next week.
Okay. But Bruce, did you have something you wanted to say?
Well, I'm not going to pick on her.
She'll kick you in the knee.
And that would be embarrassing. I don't mind getting beat up, but when women do it, it's embarrassing. I just don't understand why we need $200 million. I don't understand why we need to borrow $100 million. I mean, let me speak. Anyway, it hasn't been that long ago where we went through that whatever they refer to as the hedging fiasco, where IID, I think, finally admitted they lost 128, and there were estimates as up to 300 million. And it wasn't a loan, I mean, money we lost, but the way that was made back up is the ECA was locked in, which it was never supposed to be locked in, but that money came from the people again. Now, that's just not that past or too far in the past, and now we're talking about basically a revolving loan of 200 million. I mean, it's like a line of credit for a business, same thing. I mean, whatever you need, you can go and go up to 200 million. If you have a finite income for this entity, then the money you bring in is what you spend. You don't go out and borrow a bunch of money just because you can. I mean, it's wonderful that we would qualify for a loan, but it's always better when you don't use them. I mean, hell, my wife and I qualify for loans, but we just don't try to borrow money. And maybe we found ourselves fortunate enough to come from having nothing to, we lived with what we made, and we don't have debt because we don't borrow. And if you don't need to borrow, then hell yeah, the banks are willing to loan it to you. But why? Why would you go do that? Especially from, again, this thing that happened not too long ago, and then this deal on the QSA where and I haven't seen where it didn't happen, but I certainly does appear it did, where the escalators were taken out of it, and those were pretty awesome. That was a lot of damn money that was given away, and if 200 million paled in comparison to what was given away, and I still don't understand why it was, but if it had been left, I doubt very seriously that we would need to borrow any money, and we sure as hell wouldn't need a revolving line of credit to do it. So I'm just concerned that it's too easy to borrow this money, and it's just too hard to pay it back. Now, that said, I understand what you want it for, and I understand why you want it, Kelly. I'm Kevin, I do. But just because you can doesn't mean you should. And I think it could come back and bite us, and it bit us once. And that, it looks like it's make-up money for something that got negotiated away in that QSN. Really too bad. Anyway, leave it with that.
Thank you, Mr. Coon. Mr. Gonzalez.
Oscar Gonzalez, I want to ask this lady, I'm assuming she's an accountant. My daughter's an accountant. She's a vice president of one of the banks, vice president of Bank of America. She has an accounting degree, and she says, Dad, I've never agreed with politics, and you've always been involved, but one of the questions policymakers, and I'm going to ask her the same question, and Luis Castro picked it up, my friend, what are the options besides, what options can you give the board? What options can you give besides borrowing, I think the policy, what's begging, I think, with Mr. Benson and everybody else that I've heard, what options can you offer the board? Besides borrowing,
Actually, I think next week, the presentation that Mr. Broken will be making, he is going to make a recommendation. Different ways you can do it, rate increases, or cost reductions. Those are the two probably things that we could probably have that are under our control. We do have fixed costs that have to be met. But other than borrowing, it would either be an increase in your revenue stream, whatever revenue stream that be, or reductions in your costs, or a combination of both.
Okay, Teresa, thank you. We'll bring this back next week. We'll move on to item number 15, review and adopt a schedule for budget plan year 2013.
Move to approve.
Is there a second?
Second.
Any discussion? Please vote. Okay, thank you. We'll move on to General Services number 16, reallocation of funds to complete the construction of hazardous material accumulation yards at Nyland and Coachella gas turbine plants. Mr. Turner, you've been patiently waiting the whole meeting. Now you get your chance.
Jerry Turner, Hazardous Material Specialist with IID. And yeah, what we're looking to do, we ran out of time. We started in March of last year on putting together 2 hazmat accumulation yards. Ran out of time, and with that, ran out of the funding. And we're looking to reallocate some jobs that won't be done this year, so we can use that funding to complete the jobs, putting together accumulation yards.
Okay, is there a...
I move to approve.
Okay, is there a second? Second. Is there any discussion by the board?
Mr. Turner, the funding that you're planning on using, a portion of it is from pond erosion control.
Right.
Is that ponds there at these?
The ones there across from the steam plant, I believe. Apparently, there's some other construction that needs to take place before they can use that money, and it wasn't going to be used this year after all.
Okay, but we're not talking about water ponds in the water department.
No, this is for the fish farm, for the biocontrol, I believe they're called.
That revenue come from your department?
Okay, any further questions by the board?
Yeah, I've got a problem here.
Okay, go ahead.
I thought we kind of kept these funds separated. But we're taking from a water project and we're putting it into an energy project?
I don't think that the fish farm is part of the water department.
It's not, doesn't belong to the water department anymore, but I think that the funding for that comes from the water revenues, but it's not under the water department budget.
Yeah, it's actually taken out of environmental's budget, but it could be funded through water. I know Fish Farm used to be under you up until about 2 years ago.
Yes.
I think their funding still comes from water.
It's budgeted under General Services Department, yes.
Right.
Okay, Ed, do you have any comments on this? Director Hanks has questions about where the funding's coming from, and so come on up here and answer the questions, please.
Director Hanks, would you mind re-asking your question?
I know that General Services receives money from both sides.
Right.
Okay. And one of these projects has to do with the energy department, but yet part of the funding is coming from a project that was intended for the water side. So, at the end of the day, is it all going to swap out? And
if the project, well, I'd have to look at. I don't have the budget book with me, but if the project was budgeted as part of part of the general services, and let me look at this and see where it is. If it was budgeted within general services, then it would have an allocation to both water and energy. In other words, like you say, it would be funded from both sides. But it should only be funded by whatever side is benefited from the project. That should be whether it's energy or water. They would be the ones to fund the project, obviously. I'd have to look at the budget book and see where this particular project...
It's listed at 100% energy on page 185.
Okay. Now I don't have a problem with that.
Okay.
So the fish farm is energy? Do the fish throw out
No, that...
electrical
I'll make a motion to approve.
impulses that create energy, or how did it
it's
come
coming
to
from
be
energy.
under energy?
But I think we are,
I'm
Anthony.
not real familiar with this project, so I'd have to look into the project itself.
Excuse me, Anthony, wait, Stella made a motion, and you seconded already.
Oh, second. Oh.
Is there any further discussion by the board?
So it's confirmed that the budget, it'll be budgeted out of the energy department per their adopted budget.
According to the capital plan here.
I'm not looking at it, Kevin. You're sure what you're looking at there?
I am.
Okay, please vote. Thank you.
100%, so yeah.
We'll move on to the last remaining item under Human Services, adoption of resolution establishing retiree health savings plan.
Move to approve.
Second.
There's a second. Any questions for Mr. DeVoy?
Mr. DeVoy,
Yes, sir.
this goes into a trust, right?
Yes, sir.
And we're not going to be short funded somewhere down the line. I mean, you got good handle on this.
This is employee money. That's their vacation and eligible sick accruals that goes 100% into this plan to fund this.
Good advice. Never mess with a guy's retirement.
No, sir.
Okay, please vote.
Thank you very much.
That's the end of the meeting. Thank you.